My lord, though it is an original site, I am extreme compulsion, my lord. Rule will be issued, my lord.
Yes, sir.
No, my lord, yeah, let's say, but my lord, least in contempt, item number 7, before his lordship, Honorable Justice Parthasarathi Sen, my lord, isn't in the list, but tomorrow will be taken up.
We don't understand.
My lord,
I have determination.
my lord, it's a appeal application, my lord. My lord, that yesterday's list 150 item number before your
It's a
lordship.
division bench matter. How can I take up now sitting singly?
My lord.
Call on the list. Yes. Fight it. Mr. Bachat, if your learned juniors can indicate which volumes will be taken up first, then we can.
Not, I don't, because I've shown you a lot
Need
of
not.
papers. I don't think I'll need
Fair.
to. I'm sure your lordship remembers. If it's necessary, I'll just give the page and para numbers.
Right.
There's no point now getting into the facts. Let's try and not wind up the matter. Because not
যেটা নোট ফোট গুলো ছিল সেটা তো দাও
to use the expression, there's been much ado about nothing.
কি গো প্রথম ম্যাটার কল হচ্ছে নোটসের ফাইলটাও রেডি নেই Yes, yes.
So I'll not start off with the papers. I'll take 5 minutes to not just summarize what I've showed your lordship or what the argument is which I need to meet.
Yes.
But last day, I think we got stuck too much in papers. But to summarize, very shortly, what is the case before your lordship? The case that my learned friend has come with, is section 34, and otherwise really is this, look, I am the new management, I have come into a company, in some proceeding before the NCLT, 2 awards were disclosed. I don't have it on the records handed over by the old management to the new management. This is his case. From there, my lord, he jumps to very, very many. But that part is fact. That 2 awards are handed over to him. That he is a new management. These are 2 facts. From there, everything else is, let's call it surmise, conjecture, but for 1 fact. He says, look, I do not have it on my records. Now, if this had been a statement of fact, one would have understood. But it is not a statement of fact. He says, from the records made over to me by the old management, I have nothing to show that there was anything at all. This is his case in the petition. Now, those, not paras, I've showed your lordship the verification, but very cagey, very dodgy, very skillfully done and all of that. But the fact is, there is no fact before your lordship, if I can put it this way, or evidence in the form of even an oral statement, a proper one, that there has been nothing. Then, my lord, the moment they come to court, I point out, look, there has been a whole range of things before this, and you say you don't have the papers. So, my lord, then, to avoid this charge of suppression, Lord, he comes up with all these other things. The section 9, the orders, the correspondence, and all of that. Now, Lord, there is a mystery surrounding this whole thing. Where did these appear from? Because his initial statement is, these are all the records that I have. So, Lord, where does this pop up from? No explanation. So, it either means that the old management did not give it to him, or he had it, just did not take enough care to pull them out, or lastly, he deliberately chose to suppress it to get around limitation. But these are the 3 possibilities. Now, no explanation forthcoming. On the contrary, he says, I have no explanation. I've showed your lordship the paragraph. I don't know why the section 9 was withdrawn. I have no idea why. It shows, my lord, he is at least clueless or pretending to be clueless. Now, my lord, from there, my lord, once he comes saying that, look, there's a whole bunch of things which I don't have, which I reveal. And not that includes letter of termination, section 21 notice, application filed before this honorable court, 2 orders passed, orders record that I offered to return the not goods in question, he obviously seems to accept it because then he withdraws the application. And then, Lord, the Section 21 notice and an award, this logically follows. Now, there must be a very good explanation before one can jump to the conclusion of fraud. Because his case is very simply,
Arbitration actor. Sorry, sir. Please continue.
Lord, this nice argument he's run that the court can come to a finding. I'll show your lordship in what circumstance. Your lordships can't jump to a conclusion of fraud. I'll tell your lordship what was the situation there. But the Supreme Court in that matter had held that there is fraud from beginning to end in another proceeding. And it was held that that is binding. So even though there was no pleading at the time when the Section 34 was filed, but these bindings of the Supreme Court should certainly have been taken into account. Your lordship can't jump to a finding. Yes, I find fraud, although there is nothing to indicate. There is no evidence. I'm going to jump to it. There was a binding finding of the Supreme Court that there was a fraud. Not to pick up two stray lines from a judgment and say, your lordships, without any pleading proof, can suddenly say, because of the line, the court may find. But in that case, does it mean that the court can throw aside laws of limitation, laws relating to procedure, laws relating to everything? Certainly not. Certainly not. I'll show your lordship what it means. So, my lord, his petition is based on 5 premises. I take over management. Old management has not given me any records. Now, that itself is suspicious because there is not a single letter, not one letter from him to the old management saying, look, was there arbitral proceeding? Did you initiate it? What happened in the proceeding? Nothing. Not a single letter. Not that Section 34 is based on one solitary letter, which is this. I forward him not the awards, or rather I disclose it in my affidavit. After that, he writes to the arbitrator. Or rather, his lawyer writes to the arbitrator. Not saying that, look, there is no award. No, certainly not disputing that there was any award. He writes to him. And on that basis, he comes jumping into court. But is that any evidence at all? Now, your lordship will also remember that his Section 34 is based on everything that he relies on is post-award. Now, how much can your lordship get into it, firstly? But the law relating to setting aside that we've not seen under the 1940 Act and thereafter the 96 Act, but the language is clear. It must be not some illegality or some patent error or something not shocking the conscience which appears from the award. Section 34 is based on the premise of two things. One, non-interference by court. Two, the arbitrator is free to make mistakes of fact, make mistakes of law, etc. The court is not sitting in appellate jurisdiction. It must be patent illegality which shocks the conscience of the court, and that must appear from the face of the award. But that is the law as I know it. Now, my learned friends, which is why yesterday, well, my main junior in the matter, Mr. Ghosh, has deserted me. He's run away somewhere. So, someone else was briefed, and there's too little time. But he was discussing, and these points come very nicely from juniors. He asked, can someone just say it's fraud like this? Can I say, look, I don't have the papers. I did not know, therefore it is fraud. Can he say it? So, it got me thinking, and that's why I thought of Mr. Bose's favorite author, Shakespeare, Much Ado About Nothing. And I tell your lordship, it required a lot of skill to build it up there. But now that it has been let me explode it with his judgments and some judgment, which I show your lordship. So fraud is not based on any fact. It is not, there is no verification. He is inviting your lordship. You can come to the finding of fraud without there being anything based on those stray lines. Now, let me look at those 4 premises. I'll take 5 minutes to deal with them and then come to the judgments. But the first premise, is that he says, look, it is not on my records. Now, is that a good enough ground to set aside an award? But 4 or 5 reasons I give your lordship. 1, it may mean that the old management did not give it to him. Why should your lordship not come to a conclusion that the old management gave him all the records. In the absence of a letter by him to the old management, look, do you have anything more? Not one there. Not one. No letter, no pleading.
Yes.
Nothing to suggest that the old management did not have it. Now, this new management is again a bogey. Because, my lord, I'll show your lordship, I have the judgments. A change in the shareholding of management makes no difference. It's a company.
That's
Deceit
does require a judgment.
Correct. So deceit. So
Company
why
is the
this
same.
distinction? Because the entire case has to be based on that. Because, my lord, if there was no change of management, let us assume someone would have filed an affidavit saying that the company has not received it. That's not his case. His case is the records given to the new management do not have it. He is drawing that distinction. So that is why I'm meeting it. I'm not drawing this distinction. I say the company is the same irrespective of who the managing director is, who the shareholder is. It doesn't matter. So, my lord, there is nothing to show that the old management did not, and he deliberately dodges it, knowing that if he wrote a letter saying, was there arbitral proceeding, the answer would have been yes. Because, my lord, here the burden is on him. The burden is on him, not on me. He deliberately chooses not to write to the old management because that would have been the very simple answer over here.
Yes.
And your lordship has seen the two contradictory, my lord, averments that he has. Lord, one is based on, not in his petition, based on the records given, which he believes are the entirety of the records. Otherwise, he couldn't have come to that conclusion. And then, my lord, in the supplementary, he, Lord, pops up various other things. Lord, I'll give your lordship all the paras again, but Lord, I've showed it to your lordship. The contradictory pleading, I'll just give your lordship what it was. What was that pleading? Para 29, no? Of the petition. Yes. So, my lord, para 29 of the petition is, Lord, thus from a perusal. Well, I'll just read it for your lordship. Your lordship needn't be troubled. Your petitioner states your petitioner is under new management. The documents which are available with the petitioner basis records maintained by the erstwhile management have been handed over to the new management. Save and except documents which are already on record. The petitioner basis the available record is not aware of any other document. So he does not say, I don't have anything. He's not aware. So then in his section 9, he throws up a whole lot of documents in his supplementary affidavit. And there the pleading is just, I've got a para 9 and 10, I think. Para 10. Is it? Oh. Now just find that para. I'll just read your lordship the other para from the supplementary affidavit. Down to para 24 key. Not what
Which averment? That after making searches?
Not yes, not that and also not.
Para 10 to 12 contain many of the.
Not para 7 onwards. First, Lord, he withdraws his pleadings in the section 9, then Lord, para 7. It further transpired that after issuance of the aforesaid demand notice, petitioner under the erstwhile management had filed a section 9. So transpired. Now, how does it transpire? He did not have these records according to the pleading in the section 9. Section 34. It transpires. Now, who told him? Where did he get it from? Then, Lord, para 8, it also transpires that orders were passed. So he starts admitting everything. Now, how does it transpire? Lord, then para 9, thereafter it appears, was withdrawn as not pressed. Now, please see para 10. I say present management has not been able to find out any reason why the proceeding under section 9 was withdrawn by the erstwhile management. When Admittedly, even thereafter, dues continue to remain unpaid and unacknowledged. Then, my lord, para 11, it transpires. So, my lord, everything transpires and a bunch of, my lord, new documents, my lord, running into 100-odd pages is now disclosed. Where did this come from? Now, is this also selective? Not completely unanswered. No attempt to meet this. Then, my lord, see this para 12. Now, the only explanation is that he knew about it, but he suppressed it. Application under section 9 and the orders had been inadvertently left out. It is only after making searches has come across the application. Where has he searched? On searching, he is discovering new things. Then, my lord, please see this. Upon receiving such documents, as mentioned here in above, the new management made further inquiries and issued a letter to the advocate of the petitioner. Why on earth would he do it? Would he not first write to the management, the earlier management, the administrator, the other committee which was there, or the Kanorias, or any of those managers? They were still with in his employment, admitted position.
This was the learned advocate who appeared for them in the section 9.
Section 9. But why will he first not write to them? Because a section 9 lawyer may not be in a position to even say what. Not whether what has happened in arbitration, whether there was arbitration. This is all conjured up and arranged in a particular way. And the strange thing is, I'll show your lordship this letter. The letter written to the advocate by which he is answering, look, I have nothing on my records, is also not disclosed. It's not clear what he had given. Please see that letter. I'll give you the page. Just give me a second. I have it noted here. Just give it to me. 103. But page 103, if I may just, of the supplementary affidavit filed by them. But it gets more suspicious, but conduct has to be explained when you are alleging fraud. Reference your email of 22nd April 2024, seeking status update of arbitration proceedings. Now, that letter is not disclosed, email is not disclosed. Now, my lord, please see this. I have perused your email to the best of my knowledge, and upon reviewing my records, I certify that no reference has ever been made involving these contracts. Now, how can he certify that no reference is made? Again, my lord, he couches it in that same language, to the best of my knowledge. And reviewing my records, the second party can certify. I have never taken part in an arbitration proceeding. Yes, agreed. But why the reluctance to show this letter of 22nd April? So, my lord, he takes the steps to make inquiry. With whom? Someone who can't know. He does not make an inquiry with his own managers, with the administrator, with anyone. And then, Lord, this entire new case now is built around Oyan Chakraborty's letter, that's para 14. Now, my lord, please see para 16. How, my lord, more and more things, my lord, pop up. I say that upon further search is being made. Where? He didn't have anything more. Two communication exchange between the respondent and the administrator, then appointed, have also come to light. It appears that the administrator issued a letter. So if you got it, why didn't you write to the administrator? Then, Lord, para 70, it further appears that a reply was there. And then, my lord, para 18 is the case which has been argued now largely. Everything built around this, in reply to letter or in the correspondence with the administrator, there is no reference to the award. So this is the new case now, which is ultimately being done. Then, my lord, para 20. Please see this. I say that despite best efforts and due diligence made by the new management, what is the best effort and new diligence? Nothing, no letter written to the old management. The aforesaid documents, facts could not be retrieved or made part of the present application, as the same were discovered by the new management only subsequent to filing of the application. Discovered where? When? How? Then, my lord, para 22, present management has taken over the petitioner on the understanding that the respondent is a debtor of the petitioner company. In view of the provisions of the Insolvency Act, resolution plan has binding effect. Well, if you had the impression I'm a debtor, go catch the person who told you I'm a debtor. Catch him. Why are you coming after me and making allegations against the whole world? But please bear in mind that there is no allegation against the erstwhile management over here. Because now his case, when I come up with documents in my new application, is that, look, this manager, chief manager had no authority. Then who is the person who is filing his affidavit? What authority does he have? Please see his affidavit. Forget the verification. Forget the verification that there is nothing there. But who is this gentleman? Mr. Sanjay Jha. I am the power of attorney holder. What can he possibly know? Lord, is this? He can't even forget true to knowledge submission. How does he derive any knowledge of anything? Can he take responsibility for the statement that there is nothing more there? And but the chief manager has no authority to sign those letters or to issue any notices. That's the case made out. He couldn't have issued a Section 21 notice, etc. But there has to be, someone has to take responsibility. But these are highly irresponsible statements. There is no verification, not of any kind, which is helpful. And then from there to jump to fraud. Saying, I don't have it on record, but I don't have in all papers, I'm discovering them. Therefore, come to a finding that there is fraud. This is not the long and short of the matter, which is why not that expression, not much ado about nothing, not springs to mind. So, this is the factual background. Now, in this background, may I show your lordship a few judgments, propositions are not actually well known, but not those judgments which Mr. Bose has cited. Those are the ones ultimately I will distinguish. Where is that? Okay. I'll come there. That printout from yesterday, the judgments. I have my notes in it. Just one second, let me just pull it. But please give me a moment.
Yes.
Give me that one. I had the para numbers and all noted there. Just see if it's there in something. Yeah, got it.
You sort out the judgments, Mr. Bachad, no hurry.
No, not the judgments all here. It's because Mr. Ghosh was not here. He sent me a mail. So, at first, this change of management does not matter in law at all. It's the same entity. If the company had it, it had it. Change of management and his knowledge will make no difference. Knowledge of the management makes no difference. But the principle is not well known right from Salomon Brothers.
Yes.
Till date, there is a Calcutta judgment. I can give you a lordship. Green Hut.
Company remains the same juristic entity. So
yes.
But this proposition of citing judgment or regarding knowledge specifically?
No, same entity.
Because that's Salomon versus Salomon also.
That's right. Salomon versus Salomon followed all the way till here in Indian courts. In that case, I'll leave it. Please take it as a formal citation. Let me hand them up because one doesn't know where this fraud is going to land up. That's all. I don't want it said later. Yes. That because the judgment does not refer to it, this point was not argued. One doesn't know where this goes. The other.
But need not multiply too many judgments.
No, I won't. But I'm not
One or
even
two
going to
was-
place it. It's a well-known judgment. I'm not formally citing it, and I'm giving your lordship the para numbers also. দিয়ে দাও, দুটো দিয়ে দাও, other side কে দিয়ে দাও, আলাবারটাও দিয়ে দাও, আলাবারটাও দিয়ে দাও। ও সরি, তুমি দিয়ে দিয়েছো? But your lordship could see the second page. There's no page, there's no paragraph numbers.
No.
But here the question was whether change of management, what happens to a lease which is subsisting? Will it be a change, not change of or assignment of the lease? This is what the question was. I won't show your lordship those paras, but if your lordship just
That was regarding subletting or something like
yes, assignment of a lease.
assignment.
So the government wanted to show them out that not on the ground the change of shareholding or change of composition is a change in the person who's holding it. But if your lordship takes the third page of this judgment,
Yes.
but bottom, your lordship will find there is reference to Salomon and Salomon.
Yes.
And that summarized, and your lordship will see 6 lines from below. It was held by the house that the company had been properly incorporated, was a separate legal entity different from Mr. Salomon. It is said that either the limited company was a legal entity or not. If it was, the business belongs to it and not to Mr. Salomon. And then, if your lordship turns the page, followed in India and Bacha Gazdar, and thereafter it's become the law all over. Those are referred to. The company is a juristic person and distinct from its shareholders. It is a company which owns the property, not the shareholders. And then, your lordship will find in the next para, the last 5 lines, but the lease agreement was with an incorporated company, and just because there is a change in membership of the company does not necessarily mean there's assignment of transfer, etc. So,
Bhattacharya is incidentally relevant regarding shareholders.
Correct.
But juristic entity, this is the common thread of all judgments.
That's what
judgment to the contrary. There cannot be any judgment to the contrary.
Can't be. Dedi, you've given it, handed up, given it to them. Not if your lordship takes the next judgment. Your lordship can come straight to para 11.
Yes, 11.
The argument, the Vinod Mishra, learned counsel for the respondent, submitted, however, that subclause 5 of this document indicates that change within a company amounts to change in constitution of the company. We don't agree. And again, Salomon is not quoted, and not all the other judgments. And just after the list of judgments, there, if your lordship sees the next sentence, hence, if the shares of a company are transferred, it does not mean that the legal entity of the company is changed. And then para 19. In our opinion, last sentence of clause 11 of the annexure makes the position clear. Charges are imposed on transfer of land, but no charges can be imposed merely because of the change of directors, shareholders, or management control, unless there is also a change in the legal entity. In the present case, there is no transfer of land at all, as already mentioned above. What was transferred was the shares, but the legal entity remained the same, as already stated above. The company is distinct from its shareholders and directors. Hence, if a company is the owner of land, if it transfers the shares to someone, then there is no transfer of the land because the owner of the land remains the company. Once we keep this legal concept firmly in mind, legal position becomes clear. Last sentence, so-and-so, that no charges would be imposed in the case of changes in the constitution of board of directors, members, shareholders, provided there is no change in legal entity. Then para 21, in the present case, no doubt there is a change in the board of directors because some nominees of Fortis will come into the board, but the legal entity will remain the same. In the case of Balco, it has been held that merely because shares are transferred, legal entity does not change. That's the Supreme Court. So I'm not on this first point. This change of management is a bogey. Not if the award was not received by the old management, limitation would have started running then, and this is not hopelessly time-barred, and there is no statement by him that the old management did not receive. Now, my lord, this is on the first point. Now, my lord, coming to, my lord, this sticky issue of fraud that my learned friend is talking about. So, my lord, you're saying something. So, my lord, what is this fraud that one is talking about? Like I've said, his fraud is my records do not show I have the award. I wrote to the arbitrator and they annexed the arbitrator's letter. Arbitrator says there's an award. Therefore, I conclude because the old management has not given me the records that there must have been no arbitration, there must have been no initiation of arbitration, there must have been no appointment of arbitrator, there were no arbitral proceedings, there was no award, and everything is all cooked up. Please come to that conclusion. This is what his case is. So, my lord, first, factual basis knocked out. Why? Because I show not straight away documents which are admitted by him, which he puts up in his supplementary affidavit, which he can't dispute. He didn't know I had something more up my sleeve. But not those documents which he annexes show, number one, not there was a notice issued by Oyan Chakraborty, the same lawyer who certifies it. He had issued a letter of termination earlier. There was a Section 9 filed, which means there was a dispute. In the course of the Section 9, an offer is made to return. The offer is obviously accepted because the Section 9 is withdrawn. He can't say anything to the contrary because he says he does not know why the Section 9 was withdrawn. Now, let's not be so naive. But that offer to return must have been accepted, which is why. And then not the return did not come, or there was a dispute on the valuation of that asset, which is why the arbitration.
So, Vachat, if the offer was accepted at the Section 9 stage, then what would be the requirement of a reference after
I tell your lordship, it was accepted, but thereafter it was not returned. That's also admitted till then. Or there may have been a dispute on the valuation. I am saying, look, I'm returning asset. Today, the present value is, let's say I said 1 crore. He said, no, it's worth 5 lakhs. That's a dispute. The fact is there was
As
some
per
dispute.
the award which has been produced by you, that is the dispute, basically. That
It's
not
clear
returned and
because, my lord, your lordship will find from the award what happens. In the course of the arbitral proceedings, my lord, the asset is returned. That's recorded. And the receipt of it also, my lord, I've given. The valuation is also not there, 75 lakhs. So it was obviously a dispute on, look, I will return it, but what value will you give me? And that is accepted. Now, my lord, the strangest circumstance here. But I tell your lordship, it's been superb drafting everywhere. But the one place where it really fails is, would you not have said, I have not received that asset? There is not a single statement saying that asset is not with me and has not been dealt with by me. This was the one thing which could have perhaps made it fraud. On inquiry, he has discovered a lot of things. Why didn't he try to discover this and make a statement? Or is he not making the statement because it will go against him? So, this is the limited nature of the fraud one is left with. Not once his pleadings in the Section 9 are all let's put it this way, not thrown out of the window by the disclosures made. But then what remained were two things only. One, Mr. Oyan Chakraborty's certificate. To my knowledge, there was no arbitral proceedings. Well, how can he have that knowledge? One. And number two is, look, in that correspondence with the administrator, there is no reference to the award. Now, let me try and explain that also. But each of those letters refer to multiple contracts, 5, 7, 8, 10, 15 contracts with multiple companies. I'll show that. Once, in the end, when I deal with it. I'm just getting rid of his argument. They deal with multiple contracts, multiple claims. So the answers are all general, saying basically, look, today you are claiming rupees X against so-and-so contract. But your earlier letter, which I am annexing, shows that the claim is far lesser. That is the nature of the answers given. It was not dealing specifically with these two contracts. And that's good enough for me to explain. Now, therefore, this is the nature of allegations on fraud. Now, for fraud, I'm placing some general propositions again, which perhaps can't be disputed. First, fraud must be pleaded and proved by cogent evidence. This is the law. I give your lordship first a Supreme Court on this. Contradictory. Sharmata. Huh? You give it to the other side or no?
Oh, thank you.
Extra copy होगा रखो. If your lordship would come to para 9. There was a decree by a lower court. And it was held that the appellant plaintiffs had not pleaded necessary particulars to show fraud was committed on the court. So, one is looking at fraud on court over here. Now, if your lordship would come to what was the ground over here? The ground was that they were trying to get compensation twice over by deceiving the government. This is really the case. That your lordship will find in para 11. I won't trouble your lordship. And therefore, the judgment which had been obtained was not attempt to get compensation a second time. Now, from here, if your lordship then comes to para 14. Or please take one line from para 13 also. Para 13, just after, between placitum C and D. Sentence beginning with in support of the plea of fraud. The only contention of the appellants was that there was no lease and resolution for grant of lease was obtained in collusion with ex-pradhan of Gaon Sabha. Now, here, please remember, he says those letters are in collusion and he says there is no award. Now, please come to para 14. The submissions further submitted that as the trial court had not properly appreciated the evidence on record and decreed the suit, the same is rightly set aside by the High Court, and there are no grounds to interfere with the same. Learned counsel has submitted that though no lease deed has been executed and registered, the respondents are entitled to the benefit of Section 53A of the Transfer of Property Act. To support his contention, he relied on certain judgments which are noted, and then the next line, in support of his argument that the fraud has to be established by pleading with sufficient proof, he is relied on the judgment of this court in Ranga Kamma, etc., which I'll also show your lordship. Then, please come to para 17. In the suit filed, a declaration is sought to the effect that the judgment and decree is obtained by playing fraud. In support of the case, the only pleading was that there was no lease and in fact was obtained by creating a resolution in collusion with the panchayat. Now, please comes to para 20. Please come to it's a longish para. Please take 6 lines down, sentence beginning when the judgment and decree is assailed only on the ground that the lease was created in collusion with ex-pradhan, as the same is contrary to the evidence. The only plea of the respondents was rightly not accepted by the High Court, as at every stage the proceedings for grant of lease were approved by the competent authority, Deputy Director Panchayat. As such, it cannot be said the respondents have obtained lease in collusion with ex-pradhan, except such a vague plea. There were no particulars how fraud was played. It's fairly well settled that fraud has to be pleaded and proved. More so, when a judgment and decree passed earlier by the competent court is questioned, it's necessary to plead fraud by necessary particulars, and same has to be proved by cogent evidence. There cannot be any inference contrary to the record. As the evidence on record discloses that fraud as pleaded was not established in the absence of necessary pleading, giving particulars, we have the view that no case is made out for interference, etc. So, cogent evidence necessary. It cannot be, I believe, I think, based on my record, I submit. Everything is that.
Mr. Bachat, in this part,
Yes.
the case cited by you, there were other things also approved by competent authority elsewhere. In your case, apart from the copy of the award, Is there anything else to show
Not-
that there was an
which is why I
arbitration?
showed your lordship the course of conduct. There is a termination notice by them. One, there is a arbitral proceeding not started off in High Court. Section 9.
Section 9 may be there, but that did not.
Section 9 is not, but Section 9 presupposes that you will commence arbitral proceeding.
True.
The judgment say that very clear. You can't start a Section 9 and leave it at that. You are obliged to commence a arbitral proceeding within a limited period. Now, not just filed, order passed, records that I am giving up possession, and the award is actually that I have given up possession.
If he obtained an order in his favor, then Mr. Bachad, there would be a mandate of law for him to initiate an arbitration.
I agree.
But if it is withdrawn or dismissed or whatever, it does not culminate in a favorable order,
It
then
shows.
there is no such mandate.
Agreed. Not, I have no dispute with that. But not what does this show? It shows that he realized very well this dispute can be put an end to. That is why I am withdrawing my Section 9. How can this dispute be put an end to? By return of the asset and appropriation of money. So there is a question of valuation and there is a question of return. Now, if the two parties don't agree on a value, not a impaneled valuer, one of the impaneled valuer from the record not seems to be the situation, he valued it. And the machinery is received on the letterhead of Srey. There is also a 21 notice also which is issued by them, which my learned friend is denying because everything which comes not from our side after not his supplementary affidavit, he has to deny. That denial is also without any basis because he says that, look, that gentleman did not have the authority. Signature is not denied. It is issued by Shrey. But the gentleman did not have the authority to issue it. And he was undergoing notice period. Now, what does it mean? Does it lead to the conclusion that it is not the letter of not the company?
Circumstantially, to indicate that there was an arbitration, you say that would be sufficient, irrespective of whether he had his authority.
But it's more than circumstantial. A Section 21 notice presupposes that there will be arbitration. There is an initiation.
Yes.
And it is by a person who was admittedly the employee of the company and my lord occupying high rank. Signature is not denied. Simply says he did not have the authority and he was undergoing notice period or something like that. I think that's the case too. That's what he said. So, this is more than enough. We have started off a arbitral proceeding.
Right.
But this is more than enough in our case. But please don't mind my saying so, but the fact is fraud can't be taken so lightly. It requires a very, very high level of proof because it is in the nature of a criminal allegation. Beyond reasonable doubt is what I would have thought is the case over here. My learned friend does not try to match that level anywhere. Instead, he's throwing a quiver full of arrows. All your documents are nonsense. All my documents, well, I'm sure I don't have all the documents, or maybe I do. Today they are there, tomorrow they won't be there. But this can't be fraud for sure. It certainly cannot be fraud by any stretch of imagination. And he realizes he falls short of it, which is why now he throws it on the court. The court can find. I need not show anything. I need not prove anything. The court on its own can find. Suo moto. That's the judgment he cited, and I want to show your lordship that judgment. So, my lord, that's this first one. Then, my lord, please also take. Suspicion can't take the place of proof. Chatur bhai. This is one of the judgments that we use most often. Justice Fazal Ali was on the bench and he passed this judgment. Now, the facts of the case here, everyone knows this one. This is not one of the famous cases. And the strange thing your lordship will find, most often, not in most of these cases to do with the awards, wherever there is a not order of the court, not setting aside an award, we're talking about section 34. Rare is it that it's at the instance of a private party. It's always, not where the government is involved. Now here, of course, that didn't happen, but not here, not there was not dispatch of goods from one place to another by a company. Now the government says, I will not, and a not claim is made for compensation because the goods are found to be damaged. The government says, no, you've replaced it because there were a lot of transactions you had during that time. So you've replaced one set of goods with another. This is really not the case over here. I won't take your lordship into the facts. But they say inferior tobacco was switched with good tobacco. Now, if your lordship comes to the second page of the judgment, not about 4 lines down, the suit was resisted by the defendant mainly on the ground, not the defendant was the railways, that due to fraud and collusion between the plaintiff in Banaras and his father's firm in Gujarat, the consignment at Banaras was interchanged by manipulation and deliberation so that the inferior goods were sent to Gaya and superior goods to Gujarat. Now, this is what it was. Not para 2 is it was decreed. Then, not please see para 3. Mr. Govindo Das, appearing for the appellant, submitted that there were a number of suspicious circumstances which clearly went to show that some amount of fraud had been played on the defendant by collusion of the plaintiff and his father. So, some suspicious circumstances which shows collusion between the arbitrator and you. What about collusion with the plaintiff, with his company's employees then? All those letters, section 21, receipt, etc. He doesn't say there's collusion with his employees or his management or his erstwhile management, as he says so. And he doesn't say any action has been taken against those people. Well, there's no criminal proceedings, nothing. I'll show your lordship in the judgments he relies on. There were criminal proceedings. Now, and he relied on 3-4 circumstances. That's that para 3. Now, please come to para 4. Last 3 lines, the rest is on facts. The High Court, however, pointed out there was absolutely no evidence to show such a manipulation or changing the marks was done either by the plaintiff or his agent at Banaras. I'm not taking your lordship into the factual part. Not then para 5, similarly, reliance was placed on the fact that though consignments reached Gaya on 17th July, yet delivery was taken by the cousin more than a month later. Now here they say section 21 notice issued. You agreed 5 months later. But his section 21 was also issued not 7 months after that section 9 order. So this delay, etc.
was 7 months later.
My lord?
Your reply was 7 months later.
No, his first section 21 comes 7 months after, and my reply was perhaps 5 months later, or perhaps July and December or something like that. But that's his case. Look, you agreed to appointment of an arbitrator after delay of 5 months. So, will that be fraud? Let me understand what he's saying. Then, my lord, please come to para 7. The High Court has carefully considered the various circumstances relied on by the appellant and has held that they are not at all conclusive to prove the case of fraud. It is well settled that fraud, like any other charge of criminal offence, whether made in civil or criminal proceedings, must be established beyond reasonable doubt as per Lord Atkin in Narayan Chettiar. However suspicious may be the circumstances, however strange the coincidences, and however grave the doubt, suspicion alone can never take the place of proof. So, he may say that my concurrence 5 months later is suspicious, but that's not enough. Although I say
6.4 is also there for that purpose.
Absolutely. Absolutely, my lord. So, this is not good enough. Now, my lord, just the last few judgments on fraud, my lord, it can't be based on surmise and conjecture, because that is all that this whole petition is about. আরেকটা গিফট করতে হবে তোকে এবার আমায় পড়িয়েছিস,
আমি
আমায়
পড়বো না,
অনেক পড়িয়েছিস।
আমি পড়বো না, তুই পড়তে
না না, আমার পড়তে হলো বিকজ সৌম্যব্রত পালিয়ে গেল, ওকে বলে শুন,
সৌমাপ
ওকে বলে
পড়েছে। হ্যাঁ,
পড়েনি বলছিস তুই?
আচ্ছা,
Hey, this is aspersion. Now my learned friend is casting aspersions against the junior.
he is also my junior, huh? In many matters.
To stay away from this.
Yes, junior level discussions.
এটা কত রেফারেন্স রে?
No, the difficulty with Mr. Bose is never clear which side the missile will go, same side or other side.
এটা কি রে?
So there is a third side to it also.
Always. I don't.
That is universal.
Yeah.
It will go that side, but
But
রেফারেন্সটা
কি রেফারেন্সটা? আচ্ছা দিচ্ছি, দাঁড়া, তোকে রেফারেন্স যদি বার
AI
করে
এর
দিতে
থেকে
হয়,
নেই?
দাঁড়া এক সেকেন্ড, দাঁড়া,
এটা এআই আর না
কোনটা বলছি তোকে, দাঁড়া,
প্রিভি কাউন্সিল তো?
এটা হলো, হ্যাঁ ঠিকই বলছিস রে, এতে এখানে রেফারেন্সের পাতাটা কেটে গেছে।
তাহলে কি করে জাজমেন্ট?
The citation is 54 Law Weekly,
ল উইকলি তোর হয় না এআই?
Law Weekly page 606.
এআই এর করেসপন্ডিংটা দে
ভাই আমি এখন দিতে পারছি না, তোকে দিয়ে দেবো,
না
তোকে
না
দিয়ে দেবো। Copy দিলাম তো। আমি দিয়ে দেবো। Hey, একবার just find the AR reference now, please do that. Lord, if I may take your lordship to the first judgment, first paragraph. This is an appeal from the High Court of Judicature, Rangoon, in a suit where the plaintiffs claim to set aside on the ground of fraud a sale of land to the defendant Kasi, etc., now in insolvent. And Lord, if your lordship turns the page, the district judge had made an order, Lord, in favor of the plaintiff, but his decision had been reversed by the High Court, who found fraud was not established. That's on the top of the next page. And Lord, if your lordship goes to the bottom of that second page, about not 7 lines from the bottom, but the plaintiffs allege that the apparent sale was fictitious and entered into in conspiracy between Kasi and Sabaya to defraud the plaintiff's firm. It's alleged that the consideration money was returned to Kasi by Subaya the same day, with the result that the firm lost their property without the benefit of the price. So, not money paid, returned, but the land transferred. This is the not allegation. While Kasi enjoyed the property with the price. So, not this is the allegation. Then, Lord, if your lordship comes to the bottom of page 608. Right at the bottom of that page, just the last line, last sentence. There's no doubt that checks for 66,000 drawn on the banks mentioned above are entered in the books of RMPM Bank on 6 January, but there is nothing in the books to identify them with Kasi. Neither the checks nor the counterfoils nor the diary were produced in evidence. So, nothing is produced in evidence. This is the situation. And then, Milord, if your lordship goes to the last page of the judgment. Milord, I'll read from about 10 lines from the top.
fraud.
Yes, in this result, as it appears, your lordship has got that sense.
On the top, in the result.
In the result, as it appears to their lordships, the whole case depended upon the contents of the checks. If drawn in favor of Kasi, he must fail. If drawn in favor of strangers unconnected with Kasi, the plaintiffs fail. But neither the checks nor counterfoils were produced, nor is there satisfactory evidence that they had been lost or destroyed. Their lordships would be reluctant to decide the case on any technical objection that the evidence as to checks was inadmissible in their absence. But on the evidence as it stood, there was so little reliable evidence to connect Kasi with the alleged dealings with the bank on and after 6 January that the case of fraud must fail. There are other difficulties in the plaintiff's way, which would have been sufficiently considered in the judgments of the High Court. Fraud of this nature, like other charges of criminal offence, whether made in civil or criminal, must be established beyond reasonable doubt. The High Court was justified in holding that the judge's finding was largely based on suspicion and conjecture. And therefore, it's set aside. But it can't be done on that basis. And here, there is no evidence at all. And the evidence which he could have produced, he deliberately does not.
The next sentence also, there were documents unaccounted for which would conclusively prove the issue one way or the other. So this may
correct.
also,
Not
maybe
in this case
in line
also.
with your
Correct. Not he could have very, very easily not shown that the equipment is not returned. He could have returned, he could have written to the old management. He does not do so.
old management, administration,
Anyone.
things are not there. So
Nothing.
these are your,
Nothing.
yes,
Nothing.
premise of your.
And the last judgment on this, I know. No. Extra copy at join to the two.
আমি দিয়ে দিচ্ছি।
Judgmented copy. Having fun with.
Oh, now I understand.
Now you understand.
Yes.
That's why it's.
Why?
That's why it's.
Now I understand why you.
Now you understand.
Yes, of course.
Why, Walter?
That's why extra copy.
Even the learned judge understands.
Mr. Bose, that's why extra copy. Not very prudent to cite a judgment of a judge before him, isn't it, Mr. Bachchan? Because always we find some fault or the other in our previous judge.
But I'll tell
Always it comes to
But I'll-
when you see your previous pleadings, Mr. Bachchan, it happens to everyone.
always does.
Always you find some fault.
Always. Not we at least not Mr. Bose and me. But we always.
Everyone finds. I mean, otherwise,
My lord, the
everyone,
proper course of action is if you have appeared in a judgment, you don't cite. This was taught to me by a senior that if you have won a case before a particular, you should never cite that judgment that where you won the judgment. You cite other judgments which will lead to that. This
same
is
also should apply to the judges.
my lord.
No, I always try to discourage, but in certain cases, Mr. Bose, where there is no other judgment, recent judgment on the field, then it's all right. We can still understand. But citing the judgment of the same, otherwise, yes.
My lord,
Mr.
your
Bachchan
lordship is
is
saying
obviously not
that
doing that.
many people. Oh,
But
no, my judge.
I'll tell you a lot. Not how this.
He is obviously not doing
I'll tell you.
He knows the
Nothing.
consequences.
My lord, with your lordship, we
I
can
am
be.
doing it. Just to know
Yes, that is precisely what I.
Yes.
No, Mlad, I'll tell you, Lordship, now why this happened. But this would perhaps not happen earlier. Nowadays, because of not these good search engines which are there. Not juniors,
Goes up
when
with.
you ask them to come up with judgments, not they'll
But
give you
depending on the
judgments
keyword,
from the beginning to the end. So, Mlad, if your Lordship has
depends
gone,
on your junior, Mr. Bachchan. Don't think it depends on the AI.
No,
The keyword.
The keyword is the charge.
also does.
Keyword is the charge.
No, the keyword, I'll tell you,
The
Lordship, what
fraud.
would happen.
Yeah,
No,
fraud.
no,
Not obviously not.
No, I'm not on that. But I'm on something else. Not what happens is the tendency is not, and I appreciate because that's how we did it also. Not, but without the aid of a computer, you found the parent case,
Yes.
and then you followed it up from the noting up and other things.
That's why we love Justice Sinha's judgments. Justice S.B. Sinha's.
full melodies. So, Mlad, we love following it up. Now, what this does is it gives a chronology. So, Mlad, if your Lordship looks at the chronology of the judgments I've cited, Lord, this is the last one. That's the reason, Lord. This is Lord, earlier, Mr. Bose and Lord, my senior, Lord, all of them had librarians. That's now long gone. Lord, they would be noting up.
Yes.
So, Lord, a gentleman would come on every weekend, take all the Lord, fresh journals which had come in, look at that, see what it refers to, then take out all those volumes and make a noting.
Who's an employee? I mean, regular.
Yes.
Yes.
Lord Shubal Babu,
Yes.
and then Lord, his clerk was also doing noting up when
No.
Shubal Babu retired.
No, I had, from my father's time.
No, I know. So, Lord, that's how one got the latest without having to do a lot of research.
Yes.
It did save a lot of.
Our own books, my lord, all.
Contain those.
Yes. On the top, my lord, up to date.
Yes, I know.
That used to happen, my lord. Now
So it's not required. No?
that particular text of people, my
Yes,
lord,
Gone.
Now, that is gone.
Jobless. No?
It was very good, my lord. I mean,
Absolutely.
I still remember it was before Justice Satyabrata Sinha. My father had been his senior in many matters. He used to go there and he used to appear. So he didn't know me. I mean, my father had died. So
He
one
was
day,
in Rachin then. Of
yes,
Calcutta.
he used to, when he was as a counsel, he used to go there. I mean, all these coal matters. So one day in some matter, when I was junior, a book was handed over and that contained, 6 pages of attached, white things, so that after completing the first page, it ran over to 3 or 4. Then he didn't know. So he just looked at it and found this. And the moment he said, whose book is this? And he's asked the learned junior that, who has got these books? His son. His son practices. So he said, yes, he's there. And he was absolutely, because he had worked with him so many matters, and he didn't know, and I never also.
I am told my learned friend, my lord, his grandfather,
Yes. Oh, that was
Yes.
Justice R.S. Bachchan,
Just as
yes.
his
Halsbury,
third edition of Halsbury
Huh.
had complete noting so that he did not need the fourth edition.
Oh, acha.
That is
Fantastic.
And
Fantastic.
when I also used,
he used to note it by hand. This is what I've been told by my father.
I also have heard about that story. I mean, because that's the second edition he had.
The-
And he said, who has written this third edition? And he looked,
Missed out some.
some other Englishman.
The trouble with
second
it was,
edition is much better.
his handwriting was really, really small. There was no dot in a A that one could see. So it was very difficult to decipher. And he wrote his book also not in hand, fully. And then not the
My
type.
grandfather used to practice in the Alipur Judges Court, Justice Mr. Badrikant Bhattacharya. His handwriting was like a graph paper. I mean, it was like
Correct.
heartbeats. So it was in one go. So, but all the notes were there. All the notes.
Then not the
everything.
stenographer had a difficult time transcribing it when
They
it
did
became
it themselves. I mean, the advocates. When I saw.
Comrade, with that little
So
diversion.
anyway, I have done this, done that here.
Right, please come to para 38. Right, this is to point out whatever, not whether your lordship again.
para
credit
38
state of the, not para 38 of. Oh, I'm sorry, Lord.
Para 30 said it is expected that the said renewal application shall be decided as expeditious.
I'm sorry, Lord. I'm sorry. Yola hati legi paltega. I'm sorry, Lord. I'm very sorry.
No.
Lord, if your lordship comes to para 9, Lord, 9 onwards. Oh, Lord, those are the documents. Lord, forget it. Please come to para 15 onwards. I'll just keep it short. Lord.
Yes.
It is to be noted on the complaints on which permits of the petitioners were cancelled were to the effect that it's not possible for the petitioners to complete manufacturing of fully prepared buses within 2 days. RTA proceeding on such premise on the basis of the sale certificate being dated so and so date and so and so date. In other words, Lord, when he's got the permit, he could not have had this Lord completed because of the sale being 2 days before. Then Lord, para 16. From the sale certificates, it's evident that the same were issued for bus chassis. However, the petitioners have made out a credible case to the effect that the invoices for the chassis were issued by Bhandari Automobiles, the vendor, on so and so date. And Lord, there's some explanation given. Lord,
This is all the facts of the case. There is the proposition laid down as such. What
Lord,
writing?
Lord, if your lordship comes to Lord, if your lordship comes to 17 and 18, there. I was just pointing out what the fraud was.
In the
But
circumstances, these were held.
There is nothing to disprove the case made out by the petitioner to the effect that the petitioners had procured. Then Lord, para 18.
18 middle.
In
Yes.
fact, allegations of fraud and forgery have been leveled against the petitioner by private respondent and accepted by the RTA without any particular details of such alleged act of fraud forgery having been established by the private respondents at any point of time. Allegations of fraud, it is well settled, cannot be accepted merely on the basis of conjecture and surmise, but the details thereof have to be specifically pleaded and proved. In the present case, RTA has overstepped, and then Lord, your lordship will see, Lord, para 19, Lord, again, the last 3 lines on that page, in the absence of specific allegations being leveled or proved against the registering authority in respect of the purported collusion with the petitioner, RTA travelled beyond its authority while considering the issuance of permit to the petitioner to reopen the veracity. Then, Lord, please come to para 20. The premise of the entire observation of fraud arrived at by the RTA was conjecture and surmise. There is nothing on record to disbelieve the petitioner's case that the new chassis were handed over. Then, Lord, para 22. In fact, nothing has been brought on record to substantiate the final receipt documents, etc. Then again, Lord, para 23.
Nothing
on record.
Well.
And then, Lord, para 26, last line. Hence, there was no material before RTA to cancel the permits of the petitioner in the first place on the assumption of fraud.
Yes.
And not para 30. Para 30, about 10 lines from the top, in the absence of any proof from any side, in respect of the exact date of delivery of chassis to the petitioner, there is nothing on record to prompt the RTA to suo motu arrive at the finding that the chassis were handed over along with the sale, so and so. Although there was equal possibility, the other part is also equally sufficient indicator, your lordship will find. There's sufficient indicate, and then para 32, your lordship says, in view of the RTA having acted palpably without authority on the basis of conjecture and surmise. there's no scope of agreeing with this case.
Yes.
Ranjan,
Ah.
it at the end.
Yeah. Oh, you got it.
Oh.
41. Not the equivalent citation.
Oh,
that
thank you,
not
thank
can be
you.
into it. My learned friend has
The
been-
PV
No,
council.
not me, your junior.
Oh, thanks.
Thank you.
এই ওটা আমরা দেখেছি 2009-15 Not one last one on fraud. I'm very sorry, but
No, no.
So this is also a very oft-quoted judgment. এটা দেখবি সবকটা জাজমেন্টে noted quite often.
Yes.
And my lord, the reason is what your lordship said.
Yes.
Lord. But if your lordship comes straight away to para 38, now here, my lord, is something which I actually haven't been able to reconcile, but it's this, my lord. Lord, Contract Act says that if there is fraud, Lord, it's not void, it is voidable.
Yes.
Now, your lordship will find in a large number of cases, again, cases relied on by my learned friend, they say that, look, a decree obtained by fraud is void, not voidable.
Yes.
So, not the Contract Act itself says it's voidable, but it's not. I suppose decrees operate otherwise, but not. Now, my lord, if your lordship comes to para 38, section 16 of the Contract Act provides that any transaction which is an outcome of undue misrepresentation, coercion, fraud shall be voidable. If, however, the document is prima facie valid, a presumption arises in regard to its genuineness, and my lord, they've quoted other judgments, then my lord, please come to after the quotations. Yet again, in Anthaswamy versus Borua, this court categorically laid down that in establishing alleging fraud, it must be proved by that the representation made was false to the knowledge of the party making such representation, or that the party would have no reasonable belief it was true. Level of proof required in such a case was held to be extremely high. It can't be conjecture, my lord. And my lord, please remember this. His verification is submissions, which is not proof. A submission can never be proof. Another aspect of the matter can't be lost sight of. Not Order 6, Rule 4, my lord, I'm not referring to, I'm not reading it out. Para 40, when fraud is alleged, particulars thereof are required to be pleaded. No particular of the alleged fraud or misrepresentation has been disclosed. I've showed your lordship what is his particulars are, 3 or 4 of them, and they are all, my lord, surmise, conjecture, and not submissions, verified as submission. Para 41, we've been taken through the averments made in the plaint. The plea of fraud is general in nature. It is vague. So, my lord, that won't suffice, my lord. And then if your lordship comes to para 43, we are, however, not oblivious of the decision of this court and other high courts that illegality of a contract need not be pleaded. But when a contract is said to be voidable by reason of any coercion, misrepresentation, or fraud, particulars thereof are required to be pleaded. Maharashtra versus SEB law stated in the following terms. It's quoted, and if your lordship goes not into the 4th line of the quotation, in the show cause notice, no basis were laid to show what is the nature of fraud which was being attributed to the appellant. No particulars of the alleged fraud were given, and the said pleadings did not even contain any allegation as to how the appellant was responsible for sending the so-called fraudulent proposal or what role he had to play, etc., etc. That concludes my submissions on fraud. Now, I'll move on to another, let's put it this way, small point, but verification, again, not well-established principles, but not on verification, ठीक है. জানিস তো এটা জানিস,
Your father's favorite judge.
right?
Ah.
You know this. But if your lordship comes towards the bottom of the page, but your lordship will find a reference not to Mr. Gupta contended that under Order 6, Rule 15 of the Code of Civil Procedure, which governs verification of pleadings, verification has to be made either by the party or any one of the parties pleading or by some person proved to the satisfaction of the court to be acquainted with the facts of the case. Now here, my lord, power attorney, how he is acquainted?
The
What
supplementary affidavit was affirmed by the power of attorney, the petition also.
Lord,
Just-
same person.
Yes.
Same person.
Same person.
But how the no whether it's verified as power attorney holder? I'll just
Must have, yes. He says yes, so yes.
So,
Yes.
my lord, therefore, my lord, it has to be someone. They have to satisfy how he knows about it. No connection pleaded now. Now, my lord, the power attorney relied upon by the learned. Yes, the power attorney relied upon by the learned subordinate judge merely authorized by to sign verification of pleadings on behalf of the plaintiff, Colonel A. Stuart Lewis. Party, however, in the rule quoted above means, in our opinion, party personally, and whenever verification sought to be made by an agent, either under power attorney or under some other document or somebody on behalf of another, that verification must be justified under the latter part of the rule, namely that the person verifying proved to the satisfaction of court to be acquainted with the facts of the case. Now, here, not nothing. Verification of pleadings is an important matter which may have very serious consequences, as in the case of false verification, as has been pointed out in the decision of course, to fix responsibility on the party verifying and to prove and to prevent false pleadings being recklessly filed or false allegations being recklessly made. It must have some sanctity. And for that purpose, the rule makes provision by insisting upon the competency of the person verifying where he is somebody other than the actual party concerned, by requiring him to prove to the satisfaction of the court his acquaintance with the facts of the case. Now, nothing, Lord, in this case, nothing. This is all the more imperative where the competency of the person verifying is challenged by the other side. Then, Lord, please come to para 4. As we have seen above, the two courses should be adopted in the present case, as we've sufficiently indicated by the nature of allegations made in the plaint. As we read the plaint and as you stated above, it contains serious allegations of fraud, falsification of account, culpable negligence against the defense, and view of the
In
allegations.
your opposition to this supplementary affidavit, you have not filed. To the main petition, opposition, did you take an objection to his
I'll just
affirming? Because
I'll-
otherwise the next paras won't apply. The first para will apply.
Affidavit of competency is with the
No,
record.
that is there. Objective. That is there.
I'm not on the lack
No,
of
it's not of
affidavit.
that. Yes. He's linked with the
So, Lord, there are
facts of-
serious allegations, and then, Lord, it's only proper in the circumstance of present case that the plaintiff should be required to verify the plaintiff himself, so he may accept full responsibility, etc., etc. So that's the
If there's
situation.
an objection specifically taken.
But here, Lord, no question of re-verification. Yes, taken. I submit that Soham Kumar Jha does not have authorization to make and affirm the application or the supplementary application.
What is that? Which para?
But para 2 end, Lord, at page 3, bottom last sentence.
Eta na. Etai?
Lord, it's an affidavit.
Sumukh Sharma.
Yes, yes.
More than this. Page 3.
Page 3, para 2.
Oh, para 2.
Para 2, last sentence.
Yes, yes.
Lord, again, Lord, to digress, Lord, just a few courts across, Lord, at the end of this corridor, Lord, Justice Ajay Rai used to sit, and Lord,
Yes,
we are pretty junior at that stage. We were a little scared to be in his court because one didn't know what was turning in his mind and where he would react.
Yes.
I remember someone was moving an appeal, and it was for a company, and the petition was not signed by the managing director, and it got dismissed, saying not on the ground that, well, he doesn't have authority, but saying that, look, this company does not know how to approach court. The High Court must be approached by someone who is reasonably senior, and it was thrown out only on that ground. So, mona আছে ওটা?
Justice Rai I was moving a matter, citing a judgment in support of my case. Justice Rai pounced upon the judgment and took it and said, leaned forward and said, yes, yes, we are looking for this judgment to distinguish. Just like my strike rate was 0 there. But anyway, so
We had one more judgment.
yes.
This is not another Calcutta judgment. No,
Verification.
The smell of the lubricant in the photocopier is still fresh. Very strong.
But these chemicals tend to be strong. Sometimes your
Yes.
lordship will find that the smell stays, and some people love the smell.
Yes, I do. Petroleum, paint, these things. Yes.
Now, my lord, if your lordship would come to para 7.
7. Yes.
The contention of the writ petitioner that notice under section 184 was not served upon him has not been verified in the affidavit portion to be true to his knowledge. Only in para 7 a contention has been made that no previous notice of hearing was issued under so-and-so and no hearing was given. But same thing here, they did not get notice, they did not appoint, they did not participate. Then but para 8. The para 7 has been affirmed as submission before the Honorable Court. So far as the other contention about his filing mutation, purchase of property, subsequent action, receiving the valuation rate card, namely represented, these have been verified as true to knowledge, but so far as service of notice under subsection 3 of 184, there is neither any averment of non-service of notice nor any such averment having been verified at all. Further service of notice upon an occupier, even if it's assumed that writ petition is required to be served under subsection 3. In the writ petition, there is no averment, etc. And then Miller of your Lordship turns the page and goes to the last 5 sentences. No point not placing all the rest. Last 5 lines. In the absence of any averment to the effect that no notice was served, and that too with positive affidavit by affirming it as true to knowledge, this court can't believe the statement made in the writ petition about the grievance. Then, para 9 is well settled legal position that writ application is decided on affidavit evidence, which is the same as 34. Evidence in terms of barium chemicals reported in AIR 1967 Supreme Court, a Constitution bench judgment, averment made thereto is required to be authenticated by proper verification. Apex Court considered the issue about the consequence and or effect of any affidavit which is not properly verified. In Constitution bench judgment in Nambiar, in AIR 70 Supreme Court, the Apex Court held that without proper verification, a well-drafted petition or affidavit would be without any value whatsoever. Not well drafted, all right. Also, not I say not. That's why I say pat on the facts. Not very well drafted. Relying on the said judgment of the Constitution bench, the division bench of the court also passed judgment in the case of Liu Sang versus Board of Trustees for Calcutta, reported in so and so. My learned friend had appeared in it. Not both my learned friends had appeared in that matter. Since the writ petition was disposed of on affidavit as evidence, the Apex Court accordingly held affidavit must be properly verified and must clearly state what is based on knowledge and what is based on belief, and more so where allegations of malafide are made of defective affidavits have no probative value. It is further settled position that defective affidavits have no value. Reliance is placed on so and so. A judgment of 3 judges bench and another judgment in the case of so and so reported in this in barium chemicals, and the Apex Court further held that when the averments are not based on personal knowledge, the source of information must be disclosed, where from the opponent derived the knowledge, and affidavit should be modulated in lines with order 9. But can't get better than this. There's nothing, no verification of any kind which is of any use, leave alone not allegations of fraud. But this is a conscious attempt not to take responsibility for any statement knowing that there is no personal knowledge. Everything is submission. And not allegations of such a serious nature, not can't be accepted, not in this format. I won't multiply the judgments on this. Please give me one moment. Just give me one moment. I'll just. I don't think we cite any more judgments. There's one more judgment that I'll decide whether I need to show it or not. Just after your lordship takes a short break. In the meantime, what I'll do is I'll start now distinguishing his judgments. There are 5 judgments my learned friends relied on. I'll start distinguishing those. I may cite just one more judgment after the break. And one indulgence, if I may pray for, my junior in the matter, he is not in Calcutta for various reasons now. And the instructing advocate, the senior instructing advocate is also not here. If it's permissible at all, if your lordship thinks it's necessary, before my learned friends commence on the next day or whenever they want to, if your lordship would give me 10 minutes in case they have anything. I may not. But I intend to finish off everything, but just reserve 10 minutes for me in case Mr. Ghosh, he's worked hard on the matter. He naturally wanted to be there. But the first judgment cited by them, I'll start with why this is referred to there. Let's start with. Let's just have a look. Which is referred to induction. No? Just have a look. It is, no? Yeah, I'm right there. Okay. Now, my my learned friend cited 5 judgments. I'll just indicate not which ones. But before taking your lordship to the judgments, I'm just indicating what he cited them for. He cited 2 judgments on the necessity of a signed copy. Till then, there is no award and therefore time to start. So signature and receipt. These are 2 judgments he relied on, and then 3 are court can itself take notice of fraud. So these are the broad headings. So let me first start off with the fraud, because that's the interesting one. Or that will take a little longer than 5 minutes. So let me deal with his other lot.
We can continue after, sir. You start in your own way, Mr.
No, I'll get rid of the shorter one first.
Yes.
So he relied on 2 judgments. 2005 4 SCC.
Yes.
And 2021 7 SCC.
Right.
657. Now, one is actually following the other, and it's quoted in the other. So let me first get rid of the smaller one, because of the limited time. Now, please have a look at 2005 4 SCC 239. Here the question was, who in a large government organization like the railways is the one who should be served, and whether time should start running on the day when one goes and delivers it to some little office or to someone who was looking after the arbitration. Now, in this case, date of receipt to someone would have actually made this application beyond time. So the Supreme Court, because it is the Union of India, says no. It must be the day when some responsible officer who was looking after the arbitration receives it, because till then nothing would move. This is really what it says. Now, it's in this background, my lord, it is held that the person who has knowledge of the arbitral proceedings directly, that is the date from which time will start running. Now, if not that is the test to be applied, then this power attorney holder who is filing it, certainly he is not the person who was in control of the arbitral proceedings. It says the date on which the person who was looking after the arbitral proceeding gets it. In other words, the old management. It doesn't help my learned friend at all. Now, my lord, if I can take your lordship to the judgment, my lord. Please come to para 3. Just the first line. The chief engineer presented an application for setting aside the arbitral award.
Yes.
And your lordship will see at the bottom of the page, but that question of limitation arose because of that point. That's the last, not 2 lines on that page. I won't trouble your lordship. Please turn the page. But in para 5, section 34 is quoted. Now, please come to para 6. Form and contents of the arbitral award are provided in section 31 of the Act. Arbitral award drawn up in the manner prescribed by section 31 has to be signed and dated. According to subsection 5, after the arbitral award is made, but please mark the word, a signed copy shall be delivered to each party. So it's not the original necessarily, a signed copy. The term party, now the not only question here is who is the party. The term party is defined in 2H of the Act as meaning a party to the arbitration agreement. The definition is to be read as given unless the context otherwise requires. Under subsection 3 of section 34, the limitation of 3 months commences from the date on which the party making that application had received the arbitral award. We have to see, now let's see these next lines. We have to see what is the meaning to be assigned to the term party and the party making the application for setting aside in the context of the state or a department of the government, more so a large organization like the railways. Now, how does this help him? I don't know. But this is the limited context in which this decision is made. Now, my lord, what is said, if your lordship turns the page, but after discussing the various people who had been handling it, and in a large organization like this, not the ultimate finding, your lordship will find, my lord, after discussing the responsibility of the general manager, my lord, against placitum D, just above that, the general, my lord, just above placitum D,
Yes.
para 7. The general manager, being the head of the division, at best is only expected to take a final decision whether the award is to be challenged or not on the basis of advice and material placed before him by the person concerned with the arbitration proceedings. Taking a final decision would be possible only if the subject matter of the challenge, namely the arbitral award, is known to the departmental head who is directly concerned with the subject matter as well as the arbitral proceedings. In large organizations like railway, party referred to under 2H read with 34.3 has to be construed to be a person directly connected with and involved in the proceeding who is in control of the proceedings before the arbitrator. Now, how this helps my learned friend, but I don't know. Please see para 9. But it is the person who was connected to the arbitral proceeding. So for him, not for the petitioner in this case, time would start running on the date of receipt of the person who looked after the arbitral proceeding, not some power attorney holder. In the context of a huge organization like railways, the copy of the award has to be received by the person who has knowledge of the proceedings and who would be the best person to understand and appreciate the arbitral award and also to take a decision in the matter of moving an application, etc. And then it says why the chief engineer should be the one in this case. In para 10, your lordship will find that. And then got the last few sentences in para 10, just below placitum C. Not sentence beginning with, therefore, in our opinion, service of the arbitral award on the general manager by way of receipt in his inwards office can't be taken to be sufficient notice so as to activate the department to take appropriate steps in respect of in regard to the award passed by the arbitrator to constitute starting point of limitation. Service of notice on chief engineer would be the starting point. But this also is only the context of Lord government. I've told your lordship it gets special privileges everywhere.
Yes, yes. We'll come back and take up the next one.
I didn't notice that.
I also just
My lord, I thought
Very
you should
bad
be,
day too.
I thought you should be saying tomorrow is 14th.
crossed. Wrong way.
Everyone. Arey,
Not everyone.
arey, at all.
You can never say.
Uh,
Who has crossed?
Now your lordship is.
You can never say.
Which one did we show just now? This one, no? Yeah. Finish with this. This follows this, no? एक बार देखना it doesn't matter. But please take the next one which was cited, which is 2021
Yes.
7 SCC. Now, I'm not here. Just before I place it, I'll just tell you, Lordship, what the facts were. Facts were not there was a tribunal comprising of 3 arbitrators. So there was a majority decision and there was a dissenting decision. The majority delivered their award on a particular date. And the minutes noted that the dissenting award would be given 1 month later. And the dissenting award was given 1 month later. The only question which was involved here was, will it be the date of the first 2 awards? Because the lower court held that the date on which the majority opinion was received, because that becomes finally the award, that is the correct date. It was held that no, the award is complete when the 3rd member gives his dissenting award. That is the date to be taken. This is the authority. This judgment is authority for that. Now, Milord, please have a look at 657. It is 2021 7 SCC 657. Gentlemen. Now, please come to page 664. Your Lordship will find at para 6, the proceedings of the tribunal dated 27th April.
Yes.
Read as under. And, my lord, it records that, if your Lordship sees the portion in italics, Vide separately recorded award dated today. Claims of the claimant have been allowed with cause. Dr. Shiva Sharma has agreed with the same, whereas Shri D.S. Yadav disagreed. He shall file his separate award. Copies free of cost. Award have been supplied to both parties to come up on 12th May at 4:30 for award of not the dissenting arbitrator. So it's to come up 1 month later. Then, my lord, your Lordship sees the next minutes in para 7. On 12th May, a copy of the dissenting award was provided by the 3rd arbitrator to the parties, even though it's dated 27th of April 2018. The matter was then posted on 19th May for the parties to point out any typographical errors. The order of 12th May reads as follows, and your Lordship will find right at the bottom, arbitrator D.S. Yadav has filed his own dissenting award. So, my lord, that is the second date. And, my lord, if your Lordship turns the page now, then the later minutes show that there was no dissent to this by anyone else, for correction. And then, my lord, para 9 is the point over here. When will this 3 months start? The appellant filed its objection under 34 before the learned civil court, Hisar, to challenge the award, along with an applicant for condonation of delay. It was submitted by the appellant corporation that the objections were filed within the period prescribed by 34(3), i.e., within 3 months and 30 days from the date of receipt of the signed award on 12th May. So they are taking the second date. The civil judge dismissed the application for condonation of delay with its order dated so-and-so. It was held that the appellant had received the majority award on 27th April 2018. So, my lord, this is the background in which this is passed. Now, my lord, please turn the pages and come, my lord, to page. My learned friend relies on the other paras which I'm going to show. But I'll show one more para which was not shown by them. They had relied on para. Para 25 to 28, 36 and 44. That's what they had relied on. Now, please see para 22. An arbitral award is a decision made by the majority of members of an arbitral award, which is final and binding on the parties. Section 35 provides that an arbitral tribunal shall be final and binding on the parties and persons claiming under them. A dissenting opinion does not determine the rights of parties and liabilities of the parties which are enforceable under 36. The reference to the, I think I'll skip the rest. Now, please comes to the heading, legal requirement of signing the award. That's what my learned friend has placed. Then para 25 sets out para 31. And then please see para 26. 31.1 is couched in mandatory terms and provides that an arbitral award shall be made in writing and signed by all members of the tribunal. If the arbitral tribunal comprises of more than one arbitrator, the award is made when the arbitrators acting together finally express their decision in writing and is authenticated by their signatures. Please mark this. Here, my lord, there is no dispute about the signature. No one is saying she has not signed the award. Authentication, no dispute. Again, date of award, there can be no dispute because here there is a sole arbitrator. There are no three arbitrators. An award takes legal effect only after it is signed by the arbitrators, which gives it authentication. So, in this case, it is signed, it is authenticated. No problem arises over here. There is no allegation, it's not a signature. There can be no finality in the award except after it is signed, since signing of the award gives legal effect and validity to it. So, my lord, finality is also there on signature. Then, my lord, the next portion. The making and delivery of the award are different stages of an arbitration proceeding. An award is made when it is authenticated, i.e. on signature, by the person who makes it. The statute makes it obligatory for each member of the tribunal to sign the award and make it a valid award. The usage of the term shall makes it a mandatory requirement. It's not merely a ministerial act, etc. Now, signature is therefore not in issue over here. In other words, the making is not in issue. Then subsection, para 27. Subsection 1 of section 31 read with subsection 4 makes it clear that the act contemplates a single date on which the arbitral award is passed. So, those 2 days, the date on which the signed copy is delivered to the parties, 31.5 enjoins upon the arbitral tribunal to provide the signed copy of the award to the parties. The receipt of a signed copy of the award is the date from which the period of limitation starts running. So, in this case, again, receipt of signed copy by the company, it doesn't matter whether he has got it or not got it, the new management. And please also note the word signed copy. I'll explain that when I'm dealing with the other part. But why is there a requirement of a signed copy and not the original? That's a question which arises. Now, the answer is this: why is a signed copy? Why is the original necessary? Because it's a deemed decree. When one comes for execution, one will require the original. Now, here, time does not start running on the date when an original is given. Why is that? Because there's a power under the Act for the arbitrator to keep the original because they have a lien for payment of their fees. That I'll show your lordship when I make my next portion of my. Then, please see, receipt of a signed copy of the award is the date from which the period of limitation for filing objections would commence. So, your lordship has seen there is a distinction drawn. But one is signing. Signing makes the award final. But receipt is not relevant for a different purpose to determine limitation. That's all, nothing more. So, when will the limitation start? And it is said the date on which the party receives it. So, my learned friend tries to explain this principle further by saying, look, party must mean new management, which I have tried to say doesn't mean anything. The language in 34 is date on which the party making the application has received it. Now, in this case, the party is not the company, not the new management, number one. Number two, we tried to extend this principle further by relying on Trichy, which says it must be receipt of a particular officer. But that particular officer certainly doesn't take it back to new management. So this is how I distinguish this. Then, my lord, if your lordship sees para 28, which was also placed. Union of India versus Trichy, that I have already placed, my lord. It quotes Trichy. I have already distinguished that.
Yes.
Then, my lord, please come to para 29. Trichy is followed in ARK builders. And, my lord, your lordship will find in para 29, the third line, legal requirement under subsection 5 of section 31 is delivery of a copy of the award signed, not the original, by the members of the arbitral tribunal, because they tried to make much of the fact that she is retaining the original. Therefore, it must mean I did not get it. Answer is no. She is not obliged to give you the original. And she is entitled to keep it as lien.
But she has not said that she has not given a signed copy. She has
Correct.
not said that,
Correct.
sorry, she has given a signed copy. There is nothing on record to show that
She is only saying,
any signed copy was
she is only
received by
saying
them.
that the original is lying with me. I've given everything else to the parties. This is what she's saying.
It might very well have been that she retains the original but gave a signed copy.
Correct.
Maybe.
Correct. So, my lord, the legal requirement under subsection 5 of 31 is delivery of a copy of the award signed by the members of the arbitral tribunal, not any copy of the award. On a harmonious construction of 31.5 read with 34.3, the period of limitation prescribed for filing objections would commence only from the date when the signed copy is delivered to the party making the application. Here, my lord, there is no statement saying that the old management did not receive it, nor any inquiry. Nor any inquiry by them. If the law prescribes that a copy of the award is to be communicated, delivered in a particular way, we are not concerned with that proposition. Then, if your lordship comes to para 34, which was, no, this was not placed, but please take that. But this is only in that context. There is only one date recognized by law, date on which the signed copy of the final award is received by the parties, from which the period of limitation would start ticking. There can be no finality in the award except after it's signed, because signing of the award gives legal effect and finality. About this, there is no dispute. Signature, there is no dispute. Then, my lord, para 36 was relied on by them, which says not the same thing. Section 34 provides recourse for judicial scrutiny of award by the court upon making an application for setting aside. Period of limitation for filing objection to the award under Section 34 commences from the date on which the party making the application has received a signed copy as required by 31.5. And then it goes into other areas, my lord. And my lord, the conclusion is at para 45. It says that the date of receipt of the second arbitrator's award is the correct date. My lord, that's para 45.
Yes.
So, my lord, that takes care of the two parties. Yes. My lord, like I told your lordship can note the page 352 of their petition, saying that she has retained the original awards with me. In reply to Mr. Aditya Kanoria's notice.
And there's also her letter.
My lord.
Her letter is also there on record.
Yes.
Saying that she is retaining because they have not paid.
Yes. But your lordship will also not bear in mind that there is correspondence happening between Aditya Kanoria and them. Now, nowhere do they say that, look, we believe you have never passed an award. We believe there was no arbitral proceeding. On the contrary, they ask her for details. So they also presume on the basis that there was an arbitral proceeding, and they were only asking for records so that they could make a proper challenge. That's what the letters are. Not those letters are all annexed. All of them are asking for records. In reply to which she said, look, their fee is outstanding. Please give it to me. So they write back saying, okay, give me your Aadhaar and your PAN and other details. As if that's their letters. So she provides them with Aadhaar and PAN details. And she says, your client may be advised to deposit the amount within a week. And then, Lord, in reply to that again, he again says that the new management is now in the process of locating records. Our client requests you to provide your Aadhaar, PAN, cancelled check, copy of minutes of the meeting, and copy of letter. So, in reply to which she says, look, please pay me my money and look, don't get into further correspondence. बोले, ठीक है. Now, my lord, there are 3 other judgments which they cited. Now, my lord, one is state of Chhattisgarh, the other is state of Maharashtra, and these are referred to in, my lord, the Delhi High Court, which is really the judgment that, my lord, he really heavily relies on, because that's the one which opens the way.
State of Chhattisgarh, state of Maharashtra.
But 2010 for SCC, 2022 to SCC.
Achha, 10-4 are missed out.
And the last one is not 2023.
10-4 taken nahi. I've got 23. Devas is there.
Yes, Devas.
And
not state of
Saluddog.
Maharashtra.
Chhattisgarh versus Saluddog.
Yes.
Maharashtra, I don't find here.
State of Maharashtra versus Hindustan Construction.
Maharashtra was cited. Was it?
That's what we have in our notes.
I didn't note that in.
In any way,
Just give me-
in any case, not is referred to and relied on in the Delhi judgment. So I'll deal with that. Okay. Deccan.
Yes,
But both my juniors say it was cited. So
I've got
Take an example.
Delhi said and 2022 2 SCC.
Those are there.
2010 for বলছেন না স্যার
10-4 I don't find in my
I
records.
have extra copy
Was it cited? Was it cited separately?
but both my
In
juniors
the
say
note
so.
it's not there.
This is the copy handed over to us. But ওর কাছেই তো কপি আছে বলছে তো কপি
না না কপি করে রেখেছিল হয়তো সাইট করিনি আমি
Maybe they
I don't know if he says we have cited because I don't remember in the
because
note.
this is the one
in
which
the note
created
which-
that confusion of whether not this is within 120 days or not, because he relied on a judgment which is to do with that. But I thought, why will he not? If your lordship remembers, I had started my submission saying this is beyond 120 days. Then Mr. Bose, as usual, was correct. He said, no, it is within 120 days. So the reason I was misled was because this judgment, which is to do with 120 days, post 120 days amendment,
I think we
post
must have
120
found
day
out in a
amendment.
research because in my note which we prepared it's not there. So unless
no
of
copy
course
there.
Mr.
Very well. So
Mr.
I referred back, it is
Mitro
not cited.
cited.
No, it's like, oh, Mr. Mitro cited.
I have no idea. I don't
Like,
recall.
that one.
Is it in your copy? No. Then
Yes, yes, Mr. Mitro had said.
then we may have mentioned.
might have because it's the copy is not there.
তাহলে করিনি।
Mentioned or cited? That
No,
was the only-
how does it matter? I mean, whether we cite or not, I mean, if it's a judgment, but it's a
But if my learned friend says he's not relying on it, that's.
If you want to rely on it, you can rely on it. So that
yes.
I-
If something is against,
I'm only
me,
going to
something is against them, we
But
can.
I'm no, not against. But there's nothing. But in these matters, what is there in favor or against? It's a principle.
right?
But we look at judgments for the principle.
I'm sorry, but
If there's something against the principle argued by them, then you can cite.
I'll tell you, Lordship.
or
what-
maybe we
No, I
find it
found
out
this-
something
No, but
wrong.
I tell
Then
you,
let's
Lordship,
keep
I
it.
found it a very interesting judgment. All of these actually, we've been through these before, but it's being now used for a purpose, which is this: that the court on its own can do it.
Achha.
This is what they're using it for, and this was used on own. I'll tell your Lordship. in
Justice,
what
I now remember. Justice Ravindran's judgment has been, this is before the amendment, 2010, before that section. So,
Patently.
so therefore I did not realize. 2A came in.
Probably copies
Now I
given to
remember.
you,
Now
but it was not
Well,
cited.
It doesn't matter. No, it doesn't matter. I found it a very interesting judgment. Otherwise, all of these. I mean, so my lord,
he may have referred, Mr.
So you can delete that from your because he did not formally cite.
my lord, it's all right.
I now remember.
Okay.
Yes,
But I'll just start with.
I now remember the case. Justice Ravindran has said whether by way of amendment
Yes.
later
beyond
on,
120 days.
120 days,
Correct.
whether you can introduce new grounds or not.
Correct.
On that principle, you may say if the grounds are already there, then you can supplement those grounds.
Yes.
But additional grounds,
Whether
you can, that is
But
the ratio of.
This was cited. I remember because your lordship also asked me this question.
So,
This
but
was
this is all
cited.
prior to
Because
amendment.
this is the only judgment.
I mean, if you
amendment beyond 120 days. This argument was made.
What was held there? I mean,
Malad,
what was held there?
if it's
But I-
beyond 120 days,
Cannot.
if it's a new ground Manoj, you cannot probably. That's what it says, no? Yes.
Well,
yes.
it was cited for the proposition that even beyond 120 days, it can be done.
Yes.
I'll tell you, lordship. I'll explain. But the earlier law under the 40 Act was no new ground could be taken beyond that period.
Yes.
Then what came Bombay judgments under the new Act, which also said the same thing. Supreme Court also had said the same thing in different contexts. Now, this judgment was a little departure from that.
Yes.
Because what had happened here was a amendment was sought not in the section 34 stage, but in the Court of Appeal. In the Court of Appeal, they wanted to not amend and bring in new grounds. The court did not permit it in this case, but said that, look, those judgments don't say as an absolute proposition that you can't take a new ground beyond 120 days. This is what these judgments say.
This seems to be a reasonable view with utmost
Yes,
respect.
maybe I'll deal with that.
Not only because otherwise, but also because the court can now find it.
So
if the court
that
can
is
find
why-
it's not constricted to the
Well,
grounds.
that court can
No,
find
I'll
it
tell
was
you
not there in the section
It was not
before.
there, right.
It
No,
was not there. And
I'll say this that
just can I say
Oh,
something?
sorry.
No, if you
Sorry.
don't mind. No, I have relied on this judgment many times, Justice Ravindran, that you can introduce new ones.
Yes.
But I would say under the old act, if now, if you say the word public policy, everything under the sun is included. Everything under the sun is included. Public policy. My lord, because it has 5 grounds: patent, illegality, perversity, morality, just everything is public policy. My lord,
Because 2B was there previously also.
yes.
2B was
2B.
Small b
My
was
lord,
there, which
small
happened
b was
before.
there.
no one argued. No one argued it that way. So, my lord,
But this
so,
judgment is evidently wrong, I'll tell you, Lordship, why. But it
yes.
proceeds, not Justice, Ravindran's
Justice
judgment is
Ravindran.
evidently wrong, I'll tell you, Lordship, why.
Yes.
It proceeds on the principles of not Order 6, Rule 17, which are completely not excluded over here.
Yes.
It ignores all the other judgments which say it can't be done. Not here, clear two things. Not under the Arbitration Act, the use of the language, and in no case beyond 120 days.
Yes.
So, number one, it misses that point completely. Number two, it's not simple thing. Not Section 5 of the Arbitration Act says that court will not intervene except as provided under this act. So it lays down a kind of boundary. So, this expression court, if the court feels, can't make it more expansive. That much is clear.
Mr. Bachau,
The object was to restrict court interference.
isn't there a that is also the mistake there apparently. There's a cardinal difference between a pleading, an original pleading, and an appeal, a challenge in that sense. So in a challenge, it should be more wider in the sense that the court may not be restricted to the grounds specifically taken in writing in the challenge. Either be it an application as mentioned in section 34 says application, 37 is appeal. So whatever be the nomenclature, in case of pleadings, yes, definitely you cannot go there, cannot be any proof beyond pleadings. Now, when there's
That's
a
what
question
they
of
said.
proof,
That is
Not in fact, it said, in fact, what it required was an amendment of the pleadings. It said that unless you amend the pleadings
to
in the
file
section,
a second appeal or a first appeal or an intra-court appeal, Mr. Bachawat, do you require an amendment to the memorandum of appeal? Because memorandum is filed by the advocate.
correct. That is
And the
what
affidavit is required to amend that also. We can grant leave. Because
absolutely.
the grounds are not supported by affidavit. But section 34 is. It's a petition.
Since we are on it, let's look at this issue a little further.
Yes.
First, please remember, this is unlike a suit which is heard on evidence. Section 34, no such thing.
Exactly.
Which is why is the amendment permitted? Every amendment is permitted even beyond limitation. Why? Because it has to be ultimately proved at the trial.
Yes.
It only enables an argument. It's not a
Right.
finding.
Right.
So
If
that's
it's in
why
the grounds, if the court can do it under the grounds, then amendment should also be immaterial, even without an amendment.
In a suit. But in a 34,
Huh.
not even this judgment, not of Justice Ravindran, says an amendment is necessary. Without an amendment, you can't make these grounds.
Is that a correct view also? I mean,
But
we can say
perhaps,
it's incorrect.
because not let me. I don't know. But I don't know what was behind the thinking. But the thinking.
So what is your reason for supporting? That's more important to us.
But my understanding is this. Not we have seen this under the old Act. One could not file anything new beyond
Cannot be
120.
bogged down by that.
No, I'm not. I'm just giving you the logical
was that?
steps which are there. So, not maybe my mind has been trained to think that way. Maybe it's that, but not given the rationale behind the new Act. Section 5 says, look, non-interference by court, absolute non-interference. Then all these amendments coming to 30, not to 34, were really to narrow the scope of challenge as opposed to
Mr.
widening.
Bachat, I fully agree with you. Section 5 says no judicial interference apart from what is provided from in this.
Except as
So
provided.
then you have to say that this is provided for in this.
Correct.
So do you mean to say that section 34 has two limbs of it? The language starts with recourse to a court against an arbitral may be made only by an application. So application becomes important. But 2 small b dilutes that by saying that the court finds that. Because the second subsection 2 is.
But on that, I have a different argument. I'll come to that. But
That's
my
okay.
thinking, no, I'll just tell you a lot. I'm indicating.
Yes.
But now, all of 34 is not preceded by a requirement that whatever challenge is to come can come within 120 days, in no way exceed that. Not exceeding 120 days, it is like a cutoff.
Mr. Bachat, I'll give you my viewpoint on that so that you can just,
yes.
correct me.
Yes, I can't.
No, you can always correct me. 34.1 is recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 or 3. So recourse can be had only by making an application.
Correct.
2 is a different regime in a sense. Once you make that application, 2 says an arbitral award may be set aside by the court only if A says the party making the application establishes on the basis of record.
Correct.
But B does not say that.
Correct.
B says the court finds that.
Correct.
So I make an application on some other ground. If it comes under 2A, I have to establish that for 2A you are justified.
Correct.
2A ground cannot be amended subsequently because that challenge has been filed. But once it goes to the domain of 2B, Mr. Bachat, why should I? I don't require a pleading even. But yes, the other view is also, because why make it more restrictive?
No, I understand. But I'll just give that. And there's one more.
Since we are debating on this, may I add something? Well, subject to correction, Justice Ravindran's judgment, I believe, proceeds on this basis. Look, there is 120 days within which you must file your objection. If you cross that, gone, you are gone. That is the only strict rule.
Yes.
You file your objection. It has also been held that if you do not file an objection, you file an objection in the form of an affidavit in some matter challenging, that is treated as a section 34. There are judgments on this also. So the only restriction, if you take it wider that way, is you file something or the other, and then whether you can amend.
And now, we do precisely that in appeals. Yes. Somebody files an appeal within time, and then gets it settled.
My lord, that is one way Justice Ravindran probably wanted to look at it.
617 obviously is not applicable.
That is
everybody knows that. That was old mindset. No, but that happened.
No, so if that is the view,
yes,
this is one. The other view, according to me, because in one matter I succeeded. Same thing was as that it is. Suppose, are you supposed to set out the grounds? Is there a format? No. There is nothing. You just challenge. There is nothing. So, and I expand it further. Suppose you add the word, not the A words, the B words, public policy. Everything is included. Because public policy has been defined. my lord, under these GCQ case has 5 grounds:
Now,
perversity,
Suppose you
everything.
are- I'm going one step further. Suppose you file an application on 30.
My lord, that was my first thing which I said.
Too small a. You file an application only on that.
My lord, then according this wide view,
Court can
everything.
assume to be and
Ev-
finds
ev-
that
ev-
and
everything according, that's one view of looking at it. But if you want to see,
the
see,
other view is also
yes,
there.
I've also, my lord, been on the other side and said no, it is restricted only to grounds which you take. But if you mention the word public policy, then why didn't you take the point of perversity? Why didn't you take the point of no evidence? My lord, because the Act doesn't says that pleadings must be, grounds must be mentioned. My lord, this is, my lord, I'm sorry, my lord, if sorry.
It's always
It's taken its
to have this
My lord,
discussion.
there is no debate nowadays. No, nothing.
Nothing.
And and this is why I get disgusted at times. He said, "Why don't you?" I said, there is no fun, my lord, on this. There is, I mean, the law is discussed
No,
in a
argument as such.
argument,
Submissions-
and my lord, a hostile judge who is
Mostly.
against you.
Mostly.
I mean, there's no fun. There's
No.
no fun, my lord, in appearing in matters
Suppose I
nowadays.
become
He is
hostile only
becoming
when
an
I'm-
old man.
No,
too
there
quickly.
is no
He is
fun.
becoming
I'm
an
telling,
old
I
man too
told him,
quickly.
there is no fun appearing in any matters. now.
Hostility sometimes comes from lack of confidence also.
No, man.
I'll become hostile if I lack confidence.
Well, all of us do.
Or if you do something of such a
No, man,
serious
there is
nature,
no fun.
you start beating him up
No,
before me.
no,
Then
no.
I'll definitely become hostile.
That I beat him.
No, before me,
No.
I have to be hostile.
No, he also does the same thing. So mutual.
But he is becoming an old man too quickly. Too quickly. No fun, Lord. Why come to court then? We come here because we enjoy it. Lord.
Yes,
We
yes.
enjoy it, and that's how it has to be.
That is the only fun we have. Yes.
Now, Lord, of course,
Very well.
what Justice, Lord, I'll deal with that point. Lord,
Very
what
well.
Justice Ravindran actually said, though, at
Yes.
the end of it all, was that, look, in any case, this principle will apply once you amend it. Without an amendment, you can't get into it at all. That's what this Ravindran judgment, Justice Ravindran's judgment says. But not, I'm not getting into it since they've not
No,
cited
really.
it. But not, we may not, once we are done with this, not, I'll just need to look a little
Please.
further into how Justice Ravindran's judgment is followed other than in the Delhi High Court. Not, because it's there in the Delhi High Court. I'll just
Yes,
have a
it's there.
look at that and
So
then
in that context, you can
Yes,
cite it. No problem.
I will. Now, Lord, please come to this Delhi. Let's start off with it because this is really the linchpin of his
Yeah.
argument. Now,
Yes.
now, Lord, before that, Lord, let's just have a look at the Act once, the A and
Yes.
the B. Lord.
Yes, yes, yes.
Lord, Section 34(1), Lord, your Lordship has already placed it. Then 2, Lord. 2A says an award may be set aside if the party making the application establishes on the basis of the record of the tribunal that, Lord, these grounds are there. So this is, Lord, as your Lordships have put it, party-based. Then, my Lord, comes B. The court finds that the subject matter is not capable of settlement by arbitration under the law of India or is in conflict with the public policy of India. Now, my Lord, this, Lord, if your Lordship asks me, seems to be a demurrer-based kind of thing. Bar in law, contrary to that, or something on the face of it, not, but it pops up beyond jurisdiction. This seems to be not the limit of B that I could understand. Now, please bear in mind, not after that, a explanation is then put in to limit it. This explanation was put in to limit it. Explanation for the avoidance of doubt, it's clarified that an award is in conflict with the public policy of India. So, Lord, 2 is being limited. 2 is now, Lord, B2 is being limited by this. And then, Lord, explanation 2, for the avoidance of doubt, the test as to whether there is a confirmation of the public policy of India shall not entail a review on
It's quite
merits.
obvious, yes.
So, Lord, the object was to further limit this into saying that, look, the making of an award, Lord, for avoidance of doubt, it is clarified that an award is in conflict only if the making of the award was induced or affected by fraud or corruption or was in violation of so and so. Now, there was a reason this came.
But by introducing one instead of while limiting it, it was widened.
It was making it clear that, look, if there is fraud, knock it out.
And knock it out, for knocking out, you have to enter into the evidence.
Correct.
Induced by fraud is
Correct. It was brought in to limit it, but it was made it clear that, look,
this is the limit.
Correct. It is clarified that it's in public policy only if it is. Only if it is.
Otherwise limiting.
Correct. But it not, like your lordship says,
Does
if
not
the
remain
court
a-
finds fraud.
Demurrer does not remain.
The
It
court
does not
finds
remain at the
fraud.
surface level.
So, my lord, the first part is very clearly beyond the jurisdiction, and the second is it must pop out really that there is fraud. The making of the award was induced or affected by fraud or corruption, and then, my lord, contravention of the public policy, conflict with basic norms of morality and justice. Now, this came in, Lord, and if your lordship asks me, it's like Mr. Bose says, it is like a mantra to actually use a magic wand wherever required. Because your lordship has seen, that's the reason, most awards which are set aside, international or not, are all against the government. And that is where the court not sniffs out fraud. It looks for it. This is the tool given. Look, you can in such cases look for it. But it's not to do just with pleading. The object here is something else. Root out corruption. But
Yes.
the point is, now you look at the word, the court finds. Now, this court finding obviously must be in accordance with law. It must be in accordance with well-settled law, whether it be statutory law or procedural law or whatever law. It does
has
not
to be a
mean
factual framework also.
correct. The legal basis for it must be there.
Absolutely.
It cannot
Yes.
be not something that just because I feel like it as a court, I say the court finds fraud. It can't be that. It has to be not within well-accepted parameters.
True.
But this is not my reading of it. And then, my lord, lordship will see 2A, 2 capital A, which also came in. I've read that. Explanation 2 for the
Patent illegality.
And then, not 2A, an arbitral award arising out of arbitrations other than international arbitrations, but in other words, domestic, may also be set aside if the court finds is again used here.
Yes.
If the award is vitiated by patent illegality appearing on the face of the award. So, Miller, patent illegality appearing on the face of the award.
Twice made clear. Patent itself is on the face of it and on the face of it.
On the face of the award. So, Miller, these are the two cases where the court may find. But there is a restriction given in both these cases.
Yes.
There is a limit. And according to me, Lord, again, provided that an award shall not be set aside merely on an erroneous application of law or reappreciation of evidence, which is in line with explanation 2 to 2b, 2 small b. That you can't review the evidence, the merits of the matter, really speaking.
No.
And then, my lord, at the end of it all, please comes to 3. An application for setting aside may not be made after 3 months have elapsed from the date on which the party has received the award, or if request made from the date on which it has been done, etc., etc. So, my lord, there is a kind of outer limit which has been placed.
One other thing, Mr. Bachau, if you see 34(1), the language is recourse to a court against an arbitral award may be made only by an application for setting aside such award. Now, next part is very interesting. In accordance with subsection 2 and subsection 3. Subsection 3 does not provide any ground. Subsection in accordance with means that
the application must be in line.
Application must be in accordance with these two.
Correct.
So therefore, the application need not contain, I mean, it should contain something, but did not contain any ground in detail. Why I am telling this? Because
you're right. 34.
In accordance with subsection 3, subsection would be meaningless then. It has to be in accordance with 2 and 3. 2 says an arbitral award may be set aside by the court only if this happens. So court will set aside. It's a court which sets aside. And the application is made only in accordance with 2 and 3, has to be within that time. And in accordance with 2 means to bring to the notice of the court that see some wrong has been done. That may be also, because in accordance with 2 and 3, clubbing 2 and 3 together, the limitation and the grounds, is interesting. Otherwise, it would be in accordance with 2 within the time specified in 3. So in accordance with is used very loosely. In accordance with
Your
2,
lordship is right.
in a sense,
It's a way of giving an expansive interpretation to this.
yes.
It
has
gives it gives us the scope to argue it. It
Court-
never occurred to me.
a very interesting point. But anyway, let us not waste time on. You have other matters also, must be some.
No, Lord, I have come. Fridays I tried not to keep any matter and not done with it. In fact, once Mr. Shoma Bhaghosh said he's not here, I was relieved because I was supposed to leave with my sister who's come from Delhi. I thought that I'll leave for Shantiniketan in the morning.
Oh.
Then Mr. Bose apparently objected to his running away. So I'm stuck here. So, but I don't keep any other matters, Lord. This is a part-heard, not before a bench which.
Lord, we don't have other matters. That is more important. We don't have other matters.
Convince anyone in the court.
No,
Lord,
nothing.
But as an aside,
If your person convince them that you don't have any other, I'll be convinced.
Lord, as an aside, yesterday there was talk about there being no court after 2 o'clock. So someone asked Mr.
Yes.
Paritosh Sinha,
Yes, that
will
is
there be
interesting.
court after 2? And his comment was, well, is there anything happening before 2?
In that context, I said,
Oh, now I know.
Now, Lord,
It's too late.
but nowadays one can't even use that expression because these have been replaced by
Like
LED tube.
in LED tube. Now you have,
Instant.
and LEDs don't have that thing.
They're on
The-
instantly.
Yes.
Quicker than
Intrinsic value of being a tubelight is lost.
gone, Lord. Now one can't even make that accusation.
school days on.
Yeah.
Now, my lord, please come
Yes.
to this Divas.
Please.
And my lord, if your lordship comes to para 98, which will be in a page 77. So your lordship will find Chhattisgarh is referred to over there. I won't place it for
Inner
the
page
time.
is not telling, so
Go ahead.
I'll just find it.
Para 98.
Because this copy SS online,
অন্য copy আছে কিছু?
probably not a true copy or something they call it.
I see.
98 I found. No difficult.
Does it start with in the state of Chhattisgarh?
Oh no.
No, that's why the paras may not tell.
Oh.
But could I just take it once and
Absolutely.
এটা দিয়ে দাও না তাহলে I'll know the paras.
Yeah, the SSC,
আমার action দিয়ে দাও।
This is the copy.
Give me one copy of this so I can just tally the pages. আর কিছু না। আমি tally the paras করব। Your lordship keeps that page, I'll just tally.
yes.
I'll just
না কালো ক্লিপ ওরকম
না ওটা আমায় দিয়ে দে জজ সাহেবের কাছে তো আছে
I have this copy.
Oh, Lordship has one.
he has
Yes,
this.
I have this.
He has this.
Oh,
My copy is not para is not tallying, so
Oh.
এটা একবার দেখিয়ে নাও ওনাকে দাও ওদের দাও এটার সঙ্গে ওটা ট্যালি করছে কিনা দেখিয়ে নাও মিস্টার বুসকে is this the same copy?
আর আমারটা দেখি action
That be so, then I'll follow my.
একই তো
না তোরটা কেন
না,
এরকম
আমার
গন্ডগোল
tone,
কেন?
আমার টোন
Probably it's a true copy of the from the SSC online. That
This is also SCC online.
হ্যাঁ মানে
so there's a what do they call it? True copy or something which tallies with the book.
not to print.
True print.
To print.
True print will tally with the book. Mr. Bhattacharya is right.
ডাউনলোড করেছি
As usual, তোমারটা চালি.
Yours is not a true
তুই
print.
অনলাইন করেছিস?
Not a true print.
No, I'll just tally the para.
এটা এমনিতে খুলে এলো
ডাউনলোড করেছি কোম্পানি কেসেস
কিছু বড় স্ট্রিপলার আছে
মাথায়
গোদা
আছে?
টাইপের যেগুলো বড় হয়
No, my lord, I checked it. Something. No.
এগুলো তাহলে সেলাই করে দিয়ে পরে ঠিক আছে আপাতত দেখে নিচ্ছি ছেড়ে দাও পরে করে নিচ্ছি So you want to place para 98?
But I'll just find the equivalent para for your lordships. Just give me a moment. But I'll just pull it out. I just need to find where Chhattisgarh is referred to.
Difficulties in this that head note is also not there, so I can find out in which paragraph it has been referred in italics. That is
Just give me a moment, but I'll find it for you.
yes. আছে যেরকম ভাবে এগুলো আছে এরকম ভাবে মাঝে
Instruction is ঠিক আগে পরে হবে।
এরকম
No,
ওরকম ভাবেই করো, তুমি নিজের আঙুলটা করে ফেলো না দয়া করে। এটা দিয়ে করলে আর জীবনে কালকে তাহলে সোমবারটা কোর্ট অফিসে সোমবার সময় নেই করে না ওটা দিয়ে দিতে।
very difficult. কোনো ট্যালি করছে না।
আচ্ছা, তা ওরকম ভদ্রভাবে করলে হবে না। আচ্ছা, আচ্ছা। ঠিক আছে, আচ্ছা লাগলো লাগলো তোমার পরে এটা ফেলে করি, ঠিক আছে, কত ঝামেলা।
Hey, do something, just find the para where Mathura Prasad versus GG Boy is referred to. হ্যাঁ,
এটা সুপ্রিম কোর্ট তো, ওটা তো আছে।
The reference is after about the middle or before the middle?
well after the middle.
Well after the middle, very well.
Same. Delhi Metro. Hindustan Construction. See where you find Hindustan Construction there? Got it? Hindustan Construction? Got it. 108.
Yes, I also got
98 is 108. 98 will be 108.
Right.
The lordship can also come to blood para 90. Yes, para 107. Please come to para
107, yes.
Yes. I'm not going to
107 is-
place it, but it refers to state of Maharashtra, Hindustan Construction, which is the other one, 2010. The Justice Ravindran. Then Lord turns the page. Lord,
Maharashtra is Saluddho.
yes, that is also referred to Lord.
Yes, yes, the previous.
Now, Lord, I'm not placing it because I'll place them.
No, no, yes.
Now, Lord, please comes to para 99 of mine should be 100.
Starts with what?
Lord, please come to para 109. 109.
Yes, in both the above cases.
In both the above cases, the Supreme Court looked at the language of the provision of Section 34 of the Act and laid emphasis upon the phrase "court finds that" occurs in Section 34(2)(b) and 34(2)(a) of the Act. This phrase has been interpreted by the court as an enabling provision, allowing the court, while deciding an application under Section 34, to grant leave to amend an application. Well, that's the point. It said, look, an amendment is necessary before you can take the ground. Under Section 34, if the peculiar circumstances of the case so warrant. So, not an amendment beyond 120 days may be permitted. I'll show your lordship the para if the circumstances so permit. And it is required in the interest of justice. The court has held that the phrase enables the Section 34 to discover on its own. This is the point your lordship was on, patent illegality in the award and set it aside under 34(2)(a). It's been further held that the provision which enables a court to act on its own in deciding an application under Section 34 would also be available in an appeal under Section 37 of the Act. Now, from here on becomes not important. The phrase "the court finds that," which find mention in both Section 34(2)(a) and 34(2)(a), allow the court to look into the award and discover grounds mentioned in the look into the award. Please bear this in mind. Look into the award and discover grounds mentioned in 34(2)(b) and 34(2)(a) of the Arbitration Act. Consequently, the court enables the court to discover suo motu whether an award is in conflict with the public policy of India. As a corollary, having regard to explanation 1.1, it follows that the court would also have the power to discover on its own whether the making of an award is induced or affected by fraud or corruption, or is in violation of 75 or 81 of the Arbitration Act. We therefore find no merit in the submission of the appellant hearing that a Section 34 court does not have the power to suo motu discover grounds of public policy or fraud and set aside arbitral award on this basis. Now, why did it happen? Now, turns the page. So, your lordship has seen there must be peculiar facts. The language, if the peculiar
then it has to be on a very high ground because 6.4 is not available. So then court has to proceed very cautiously, undoubtedly.
not grant leave to amend. That too, if the peculiar circumstances of the case so warrant. This is the limit now set down.
Yes, but the next paragraph, Delhi High Court holds that suo motu also can the court
Please see,
can do.
please see when. Please see now, Lord.
Huh.
This is what I want to show you, Lord. Suo motu, yes, but only when, Lord, the burden or the threshold is extremely high. Now, Lord,
It has to be higher, in fact.
Lord, please see the level of how high it was in this case, 101. The facts of the present, oh, sorry, not 101.
11, 111.
The facts of the present case are nothing short of peculiar. So first, your Lordship must find peculiar facts. How? Devas has an arbitral award amounting to 562.5 million along with interest and costs in favor. While the award was published on 14 September, there have been 2 charge sheets filed by CBI against Devas and other individuals alleging criminal conspiracy, fraud and corrupt practices on so-and-so date and so-and-so date, and investigation regarding the same is ongoing. Nothing criminal over here. Now, while the proceeding in the underlying Section 34 was pending, the Supreme Court upheld the decision of the NCLT and the NCLAT to wind up Devas on the ground that it was formed for a fraudulent and unlawful purpose, and the affairs of Devas have been conducted in fraudulent manner. The Honorable Supreme Court, in its judgment passed in so-and-so, has confirmed certain findings of fact which have attained finality and are binding on the parties and this court. On the basis of these findings, the following observations can be arrived at. So there is already a finding by the Supreme Court which is binding on all, that the formation of the company itself and the making of the contract which led to the award is fraudulent. Not 101. Sorry, not 111, 101.1, which is quoted in 111. It is well established that Devas was incorporated with fraudulent intention so that it could enter into the Devas agreement with Antrix. Devas could manage to do so only by conniving and colluding with the then officials of Antrix, which assisted Devas in entering it into the Devas agreement. The collusion between the officials of the DOS and Antrix is borne out from the note of the 104th Space Commission, which did not contain references to the Devas agreement. Cabinet, which was prepared 10 months after signing of the Devas agreement, did not make any mention about Devas or the agreement, but the cabinet proceeded on the basis that ISRO had received multiple expressions of interest from various entities. Therefore, the cabinet was kept continuously or completely in the dark, and material information was suppressed by Devas when cabinet approval was obtained by Devas. Further, the cabinet was misled to believe that there were several firm expressions of interest before ISRO, even though this agreement was granted only to Devas. Devas has thus not only suppressed but also misrepresented information in order to pursue its fraudulent activities in India. Devas is an agreement of huge magnitude pertaining to leasing out of transponders to Devas on primary satellite 1 without the same being preceded by any auction or tender process. Here, Mlad, everything proceeded by a Section 9 and a Section 21 notice. It is also established that minutes of the meeting were manipulated and an experimental license was granted, and the original minutes were restored on so-and-so after protest, etc. And it goes on, Millard, into what are the fraudulent conduct. Then, Lord, please come to the next para 102, perhaps that will be 112.
Yes.
A reading of the aforesaid facts clearly established that the fraudulent conduct of Devas begins from the very incorporation of the company and extends to the Devas agreement in its entirety and all other actions pursued by it. The nature of fraud is so serious and so complex that it not only resulted in the company being wound up under the Companies Act, but also led to criminal investigation against the company and its affairs. The Devas agreement itself has been obtained through process of fabrication of documents and misrepresentation and constitutes a clear case of fraud. Such clear case of fraud. Such is the extent of fraud that it permeates through every agreement, transaction, or award entered into by Devas. The fraud propagated by Devas is not only against respondent number 1, but against the state as a whole. So, Lord, fraud is against state as a whole, and inasmuch as it attempts to obtain monetary benefits from the state itself by attempting to enforce arbitral award, which itself arises out of fraud. A fraud of such scale would certainly render the award to be in conflict then, my lord. In view of the aforesaid judgment, specific amendments to this to Section 34, and in view of the categorical findings of the Apex Court in Devas Civil Appeal so and so, nothing prevented the learned judge from relying on these findings. So what it's saying is you are relying on judicial findings.
Yes.
But the court is not jumping to a conclusion. It is relying on a not judicial finding. Nothing prevented the learned single judge from relying on these findings and using them for the purpose of setting aside the ICC award under 34, and on the ground that the agreement itself was a product of fraud, and therefore the making of the fraud is automatically induced by fraud and corruption. Findings of the apex court, which is the highest court of the land, could not have been ignored by the learned single judge, and those findings would automatically become findings of the learned single judge while considering an application under section 34, for which there was no necessity of specific pleading. Because, my lord, it's a judgment. There is no need to plead a judgment.
Mr. Bachau, with due respect here, the public policy aspect was brought in because there was a fraud against the state also and all this.
Correct.
But public policy of Indian law, there is a distinction between public policy of India and fundamental policy of Indian law.
Law.
Now, public policy of Indian law, public policy of India has been restricted to contravention of fundamental policy of Indian law or morality or justice. So therefore, suppose Indian economic policy is affected, like in this case.
Correct.
That cannot be a ground. It has to be a contravention, violation of fundamental policy of India. Because if you please see, to small b, 2, Roman 2, arbitral award is in conflict with the public policy, which is very wide. It can be against
Correct.
India also. But then explanation 1
Correct.
clarified only if, and only fundamental policy comes in only in Roman 2 of explanation 1. Fundamental policy of Indian law. So therefore, public policy of India, even if it is affected economically or secularism is affected or sovereignty is affected, even then it cannot be a ground. It has to be contravention of fundamental policy of Indian law.
Possibly,
only if.
possibly fell into 3, conflict with the most basic notions of morality or justice.
But then morality or justice is in adjudication. It's an morality cannot be
Justice. There was
societal morality cannot be.
Justice was this adjudication by the Supreme Court here, I suppose. This is what they were probably looking at.
Justice has to be an adjudicated process. The moment you say justice. And morality, justice, Nariman's judgment is also there. Morality usually used to be in the social context and all. But morality has to be on this. Morality has to be on legal principles. Morality, my morality may be different from yours. So it's very, subject to interpretation still. Law is not, has not crystallized at all. Delhi's view is yes, public policy of Indian law. But nobody listens to Calcutta's view. But appears to be, it has been now restricted to fundamental policy of Indian law, which is different from public policy of India.
Correct.
This has been watered down by the explanation 1 itself. Anyway, so very well. This is, you say this is on a very high ground.
Very high ground.
Yes.
And also, please see, not just one more para. I'll just last aspect. Para 115 in your lordship.
115, yes.
The last aspect to be considered is the contention of the learned senior for the appellant that the general observations regarding fraud cannot be applied while considering an application under section 34 of the Act without satisfying the ingredients of section 17 and 19 of the Indian Contract Act. It is his case that the general principle of fraud cannot be applied when there are specific provisions, namely 17 and 19 of the Indian Contract Act, and explanation 1.1 to section 34 2B2 of the Arbitration Act would prevail over this general principle. Now, at this juncture, it would be apposite to elucidate upon the principle of fraud vitiates all solemn acts as has been expounded through judicial decision. The Honorable Supreme Court in blood, this is again not
the rest does not help you. Rather,
no, it doesn't.
Then they're
of course.
Why does
they have cited it? So I'm just not. I'm going to take care of this principle. Not if I'm trying to. So not it quotes. Not this Chengal Varia Naidu.
This is entirely quotation, yes.
Not that, this was that famous case on fraud. And, my lord, if your lordship sees, please, on the next page.
(120 and 121).
This was the clean hands principle. Then, my lord, following this decision, commission of fraud, all of this is not taken care of. And then, my lord, but all these judgments which my learned friend referred to, Satledge, etc., those are discussed over here. And not the finding is ultimately
fraud is viewed seriously and all these things. Obviously, it is has to be.
Now, let 111 here would be, we see no merit. So that argument is dealt with in para 121.
Yes.
We see no merit in the submission that the principle of fraud vitiates all solemn acts is a general principle and a special principle. A provision will prevail over the same, even in instances where the subsequent proceedings or collateral proceeding pertains to the application of special provisions of fraud. The factum of fraud having been established in a previous proceeding will affect all transaction proceedings which have been tainted by fraud. In the instant case, Supreme Court has held that the commercial relationship is a product of fraud and as a consequence, etc. So, this is directly flowing out of the Supreme Court judgment. So, here no pleading of proof was required because, it is the law laid down by the Supreme Court of India. And what is said over here is courts take judicial notice of this. Which cannot not mean that one can expand this court on its own, or suo motu can do it. It must mean it within the ambit of law for whatever it is. It's within that. Since your lordship has thrown up an interesting little point, I may take a little more than 10 minutes on the next day.
Yes.
If I have anything interesting on this 34 2A versus 2 capital A, the court, I'll look into it. I'll look into that. And that will leave the two other judgments. Well, he's not relying on Justice Ravindra's judgment. He's only therefore that leaves only that Sal, which is considered in Delhi. There's nothing new over there. That was at
You can deal with Justice Ravindra's judgment also.
I will then in that.
Because to just not to take any chances. I mean.
So, this we have that time, let me knock off state of Chhattisgarh also, 2022
Yes,
to
yes.
SEC.
You're knocking off state after state.
All I'm showing is
Delhi.
State. State is a preferred customer. State is a preferred customer. This much one can make out.
That is the only settled proposition of law without saying it. It has been the contrary has been repeated in judgment after judgment, but
correct
everywhere.
I mean,
just imagine your one of your employees receive notice, but because you are a large company, if he does not have direct knowledge of, how can you distinguish intra-party?
It's
intra-party you cannot distinguish. Government is a government.
It's astonishing how far
we can go
to. Fortunately, unfortunately, neither Mr. Bose nor me are preferred customers in this case. But so, again, in the context of state of Chhattisgarh, the next judgment. Now, the court again invents a ground over here. I'll show that on the next day.
Can you give the judgment which you are citing 1 day in advance so that we can finish it off?
If I do.
Yes, absolutely.
I will.
তাই তো বললাম
আচ্ছা ওই একই আগের দিন heard in part. This is the matter for further hearing on February 20, 2026. এইগুলো একটু আলাদা করে রাখতে হবে, এগুলো একটু আলাদা করে রাখতে হবে। List. 1 to 3 yes. Why appearing? 2 minutes. Huh. Our part in the date of the
I'm on behalf of the.
yes, in the order dated February 6, 2026, comma, CO number 852 of 2020 was erroneously mentioned in the caption as CO number 852 of 2006. Full stop, next para. Accordingly, the caption of the order dated February 6, 2026 be deemed to stand corrected to the effect that double inverted CO number 852 of 2006 double inverted close shall be read as about quote unquote CO number 852 of 2020. Full stop. This order be deemed to be a part of the order dated February 6, 2026. Thank you.
Item number 4 to 6.
The
But unfortunately, my lord, the appeal is still pending.
appeal is pending.
Yes.
No, this is what?
This is, my lord, 456, my
No,
lord.
I mean, appeal is pending against interim order.
There, in fact, my lord, there the interim order was not even appealed against.
Then
As so moto, my lord, invoking order 41, rule 33, my lord, the proceedings are stayed. Very unfortunate, my lord. We are trying our level best, my lord.
no, how? I mean,
I
something
may-
must have gone before the court. There's an appeal.
There is an appeal, but from the interim order, my lord, it so happens there was no appeal.
So appeal was against what?
Against an ancillary order where my
Ah.
lord, State Bank, my lord, was not given liberty to participate.
Right.
There we consented, saying that very well, let it be allowed. Let them be a party.
Huh.
But then, my lord, the learned ASG, my lord, submitted that we also want to challenge the order which is not appealed against by invoking order 41, rule 33. And, my lord, despite my lord Ramkishan Fauji, my lord, which clearly says, my lord, that when the single judges, my lord, passed an order in criminal jurisdiction, if your lordship recalls, my lord, we are asking for quashing of the FIR.
Yes.
Despite that, my lord,
No, there is a stay of this proceeding in there.
proceedings, yes, proceedings.
Oh,
Yeah, that's why, my lord, it's again fixed on the 18th.
18th of this month.
Yes.
So we'll keep it sometime in March. 13th of March.
I'll be grateful, my lord. In the meantime, we'll definitely not.
Very well. Learned counsel appearing for the petitioner submits that the appeal pending in connection with the matter bearing MAT 1409 of 2025 is still pending. Full stop. Since, comma, video order dated September 17, 2025, comma, the appellant bench had granted an order of stay of all further proceedings before this bench, comma, let the matter stand adjourned till March 13, 2026 to await the outcome of the appeal, comma, as the court is apprised by learned counsel that the appeal has been fixed for hearing next on February 18, 2026.
Grateful. Number 7.
In this matter, I am appealing on behalf of the Principal Accountant General, my lord. So we are not a party in the, but
Rule was issued against you,
no.
Mr. Prasad, against your client.
Yes, my lord, what happened, my lord? My lord, this is that matter, my lord. The widow daughter pension is
Yes, yes.
awaiting. Now the entire thing has been gone to the my lord, senior accountant officer AG Bengal. They have raised certain objection. It was again complied with. My lord, entire file has been again my lord resubmitted.
And PPO has been issued.
My lord, okay, that has been done.
PPO has been issued. Exactly what does it mean? They'll get the money when the particulars of the PPO. You do know about this?
I'm giving you.
Please give copy to them so that they can take the money and we'll put it next Friday.
Lords.
Learned counsel appearing for the alleged contender submits that there were certain objections raised by the accounts department, comma, after which the file has been resubmitted. For some next para. At this juncture, comma, learned counsel appearing for the
My lord, Farhat, you have not been.
AG, my lord, Lordship was kind enough to direct us to effect
No,
service upon them along with the copy of the order, so that on the next occasion, my lord.
learned counsel for the AG. Learned counsel appearing for the senior accounts officer submits that
pencil payment order has been issued.
does it say that following that the necessary pension payment order in favor of the petitioners has been issued. Puts up a communication in that regard dated January 28, 2026 is handed over in court today and kept on record. Puts up a copy thereof is also served on the learned counsel appearing for the petitioners. Puts up next para. Liberty is given to the petitioners to approach the appropriate authority for accepting the amount disbursed to the petitioners in terms of the said order. Puts up next para. To ascertain the outcome of such approach, comma, let the matter stand adjourned till we'll keep it after 2 weeks. So you'll get some.
But if Lordship kindly allow me, I can make one submission. But as it appears from their paper which they have supplied, at the bottom there certain documents are required to be submitted to them. That document we have submitted, but no people.
Take copies.
Yes, yes.
Let the matter stand adjourned till February 27, 2026, when it will be listed under the same heading.
But meanwhile, nothing prevents them, my lord, to credit the amount in favor of the petition.
No. As and when so approached, comma, the respondent authorities shall disburse the amount in favor of the petition.
Deeply.
And rest of the thing, my lord, we have already given to him.
Yes, sir. And the personal appearance was dispensed with.
Yes, my lord. May I submit my instruction also, my lord? I have been given.
Written instructions filed by learned counsel for the alleged contemptors today be kept on record. A copy thereof is also handed over to the learned advocate for the petition.
I'm grateful.
Thank you.
I'm grateful.
Give the names.
Yes. Thank you.
This is the second occasion when none appears for the petitioner at the time of call, full stop. Accordingly, CPA 66 of 2020 is dismissed for default without an order as to cost.
Item number 9.
None appears for the petitioner as none appears for the parties at the time of call, full stop, next para, as a last chance to the petitioners to move the contempt application, comma, the same is adjourned till February 20, 2026.
Number 10.
Same order.
Item number 11.
May please, my lord, this is that, my lord. Contempt, my lord, application challenging, my lord, the act of the bank, which in our most humble submission, my lord, is in contumacious violation of your lordship's order of 9th of August 2024. In the last occasion, my lord, your lordship had indicated
copy. You have served a copy?
Yes, my lord. Served a copy.
Affidavit service.
My lord, I tender my apology, my lord. I'm just instructed, my lord. The affidavit of service is not ready. It will be filed over the course of the day. That is, my lord, why. Yes, my lord. I've
for
the respondent.
Well, I am appearing in this matter.
My lord, I undertake, my lord, we'll file the affidavit of service in the course of the day, my lord.
Yes, since Mr. Dewan is appearing. Yes, Mr. Dewan. What is the?
Because I am opposing the application and I'm saying it's not maintainable.
Why?
If your lordships only hears me for 5 minutes, I may be able to persuade your lordships to dismiss it straight away.
Very well. Yes, Mr. Dewan.
Yes, now, Malas, would your lordships look at Malas page number 743 of volume 3, which is the order dated 9th of August 2024, the violation of which is complained of.
Uh, 700, sorry, please.
Or 743.
43.
Yes. Now, Malas, this is a common order dealing with 3 writ petitions. In this, we are concerned with the third one, WPA 1223 of 2024.
Yes.
Now, your lordship will see this is a consent order, and the relevant Malas paragraph is paragraph 6 at page 746.
Yes, 746.
Yes, so Mullahs, 746 paragraph number 6, your lordship will see the WPAs are disposed of by directing the following. Now the first paragraph says, although the respondent banks have served a copy of the KPMG forensic audit report, respondent banks through counsel will serve a copy of the full KPMG forensic audit report along with all volumes of annexures and enclosures to the counsel for petitioner by August 10th in good faith. This has been done with, there is no grievance regarding giving the full FAR. Now please turn over page 747, paragraph 8. Petitioner in each of the writ petitions would furnish his reply to the show cause notice within 21 days from today, indicating the documents which are required to be inspected furnished to the petitioner, and please mark this line, to effectively rebut the allegations made therein. And now paragraph 9. Upon such reply being given, respondent bank in each of the writ petitions shall fix a date for giving inspection of documents if extremely voluminous. Alternatively, the bank shall furnish copies of relevant documents to the petitioner within a fortnight thereafter. This is the order passed. Now your lordship will see on 30th of August 2024, the petitioners or the petitioner gave a preliminary response to the SCN asking for documents. That your lordship will find at page number 749. Of the same volume, alerts. I'm sorry, of the same volume.
Yes, right.
Yes, now lordships, your lordships has that page 749?
Yes, I do.
Now, your lordship will see this is the preliminary response issued pursuant to the order, which I have just shown to your lordships.
Yes.
Now there is a whole segment of introduction here, which I'm not going to bother your lordship with. I only wanted to show the list of the documents that they have sought for. And that your lordship will find at page number 770. In fact, kindly come to 762 first. I'm so sorry.
762, yes.
Yes, now your lordship will see issue number 1.
Right.
And this is instances of issues relating to credit exposure to customers internally classified as high risk. This is an issue in the show cause notice. If your lordships don't mind, can I just show the show cause notice? My friend is carrying copies. So your lordships can just have them together. The show cause notice has not been filed with the contempt petition.
You can give a copy to them also. Yes.
This is part of the.
Part of this?
Yes, Miller, that's page 700, Miller, of volume 3.
Oh, I'm sorry, then I may have missed it.
It's all right. No difficulty. Yes, 700. Yes, 700.
Yes, so if it's page 700. Yes, so your lordship. Yes, now Mullahs, kindly just see the first allegation.
May I just interrupt? Mr. Dewan, you're referring to the show cause notice issued by which bank?
I am referring to the show cause notice issued by this bank, the one in contempt, which is South Indian Bank.
South Indian. Page 700, my lord, is Central
That is
Bank.
Central Bank.
So therefore not filed.
This is South Indian Bank.
This is South Indian. May I hand?
Yes. Thank you.
Yes, so now your lordship, in this document which is handed over, kindly turn to the second page and your lordship will see at the bottom of the page, paragraph 7. And there is the first allegation, namely instances of issues relating to credit exposure to customers internally categorized as high risk. Yes. And now your lordship will see the observations from the forensic audit report have been reproduced there. And these are some facts that we have given. I'm not going to take your lordship through this, but right at the end of it, just after 6 on the next page, is the question. What is your specific response to the above illustrative loan cases where loans were extended to borrowers internally known to be high risk and highly vulnerable to default? Why were loans extended to customers with poor quality rating? Yes. This is the question that we asked, and we gave the fact in the preceding paragraphs. Now, kindly come back to the writ petition, now, because where the list of documents was there, page 762 I had shown. Now, let's kindly just, your lordship will now see this. What all documents they are asking for? Your lordship will just give me 1 second. I'm sorry. Yes, so 762 is the response to this allegation where it begins. The list of documents that they ask for comes a few pages later, at page number 770, paragraph number 83. Now, just kindly have a look generally with what information they are asking for. 83, I'm reading 83 now. 83A.
Yes.
Names and details of all officials of your bank who were involved in granting subject loans to the SREI entities. Names and details of all officials of your bank who were monitoring the manner in which your loans to SREI entities were being utilized. Names and details of all officials of your bank who were scrutinizing the loan accounts. D. Copies of appraisal reports prepared by the bank officials in respect of loan accounts mentioned. Copies of minutes of meetings of your competent credit committee, etc. F. Copies of minutes of all meetings held in your bank by your competent authorities where loan accounts and loan proposals of SREI entities were placed and discussed for the purpose of sanctioning loans. And it goes on and on till the next page. Actually, the last heading is serial number K. It is our case that these documents have no nexus at all with the questions that we asked you in the SCN. You are asking irrelevant documents, and these documents are not required to effectively rebut the allegations raised in the SCN because that is the qualifier in the order put. Now, I have only shown one allegation. Your Lordship may see one more allegation just to tell your Lordship as to what kind of documents are now being sought from us. Your Lordship now will come back to the show cause and now look at illustratively allegation number 3, which is instances of issues of potential evergreening, round tripping in the guise of refinancing loans.
Yes.
Just kindly see observations from the forensic report. And we have pointed out, look at paragraph number 4. We have given a specific example of some company called Hiranamaya Energy. And we have said some allegation regarding that. Then there is Bengal Srishti Infrastructure Development in serial number 5. And then there are factual allegations. And please see at the end of it, the specific question asked, above instances and treatment of loan transactions in the books of account of SREI entities shows various instances where end use of loans given by SREI entities is consistent with the pattern of round tripping, evergreening to service, etc. There are also instances where the loan disbursement were not used towards the purpose for which they were granted as per the loan agreement, instead used to repay loans of other entities. What is your response to these specific allegations? Please now, kindly go back to the SCN, to the writ petition, to the contempt petition. I'm so sorry.
Yes.
And again, look at the documents that they're asking. This comes at page 779, where this allegation is sought to be responded. 779. And your Lordship will see the answer begins from issue number 3, instances of issues of potential evergreening, round tripping. The list of documents asked for is at page 783 in connection with this issue. And please look at the list again. Names and details of all officials of your bank who are involved. Pretty much the same list that I shown on the earlier page. And this pattern your Lordship will take from me, I say so responsibly, happens with every single allegation in the SCN. So what is now being done is that your Lordship's order is being read to say that please give me whatever documents I ask for. Whether it has relevance to the allegation in the SCN does not matter. Their interpretation of the order is whatever they want should be given. And this, by the way, they say so specifically. I want to only show one other page, 2 other pages. Kindly come to page number 800 of the very same contempt petition.
Yes.
Which is the bank's letter of 13th of September 2024, where we respond to this earlier letter of 30th of August. And your Lordship will find that the bank's responses, may I just read it? We acknowledge receipt of your preliminary response dated 30th of August 2024 concerning the SCN issue to you. In response to your request for the additional documents, we are providing the documents that are available with us. However, it is noted that many of the documents you have requested pertain to data documents which is to be collected from SREI entities, and few of detailed documents is with regard to our internal details documents which is privy to the bank. Hence, we provide the below comments with respect to documents which are connected with our bank on classification and reporting as per RBI master directions. So bank says, well, you are not entitled to internal documents. If the allegation is evergreening, for example, what are you going to do with my documents, my bank committee, my meetings, etc.? You have to answer the allegations. And the most important now is their response of 25th of September 24 to this letter at page number 806.
Yes.
And that, according to me, is an answer to this contempt petition. Well, let's kindly come to this letter at page 807, bottom paragraph number 5.
Right.
Now, this is what they say. Further, it is no longer open to the bank to contest the relevance of the documents information sought. Honorable High Court at Calcutta in the said order as held as directed, and then they quote the order, which is actually what they have quoted is the earlier order of 2nd of February, but it's pretty much the order of 9th of August. So now, to my answer to the contempt is as follows. Today, the parties are at contest between what was meant by the order. Did it mean that
Mr. Dewan, did you furnish copies of the documents which were available with you?
Well, we have provided the full forensic audit report along with the full annexure volumes. Your Lordships has seen the letter of the bank of 13th of September 24. One or two documents are also given with that. But the documents that the bank thinks are irrelevant and have no nexus to the questions have not been given to them. Now, the contest between the parties is what is the meaning of the expression effectively rebut the allegations made therein? Is it left to their discretion, or is it a more objective exercise? Now, to complete the narration of facts, what happened in SIIB's cases, after this contempt petition, etc., they have been declared as a fraud. Because they never turned up for the personal hearing, we have declared them as a fraud. And that fraud order has been challenged by filing a separate CAN application in a matter. Now, according to me, it is for that court which is seized of the CAN, in which the issue is whether they have been rightly declared or wrongly declared as a fraud, to decide whether these documents are relevant to the inquiry or not. There, in my submission, there can't be any carte blanche that whatever you want should be given to us. Otherwise, there is a contempt of the order. Well, the contempt jurisdiction, as I understand, subject to correction, is only for willful defaults. The facts today before you don't disclose a case of willful default at all. It is not that we have deliberately not given them the documents. We have not given them the documents because it is our understanding the documents are not relevant. And of course, they are trying to prolong the inquiry by asking whatever they want. Now, only one judgment I wanted to show to your Lordships before my friend takes up, because there is a judgment of the Supreme Court. Your Lordships are aware of the law, but one judgment may I just show, because which is the Supreme Court case of Ram Kishan versus Tarun Bajaj. It follows, Malods, the earlier decisions on this point.
Yes.
But just have a look at one or two paragraphs. Paragraph 11 of this judgment at page 8.
Yes.
Because contempt jurisdiction confers on the law courts power to punish an offender for his willful disobedience, contumacious conduct, or obstruction to the majesty of law for the reasons that respect and authority commanded by the courts are greatest guarantee, and to an ordinary citizen, right shall be protected. Now, in this very same paragraph, there is a line which says, undoubtedly, the contempt jurisdiction is a powerful weapon in the hands of courts of law, but that by itself operates as a string of caution. And unless thus otherwise satisfied beyond reasonable doubt, it would neither be fair nor reasonable for the law courts to exercise jurisdiction under the Act. Proceedings are quasi-criminal, therefore standard of proof required in these proceedings is beyond all reasonable doubt. And Malos, kindly look at paragraph 12 now. Thus, in order to punish a contemner, it has to be established that disobedience of the order is willful. Word willful introduces a mental element, requires looking into the mind of a person, contemner, by gauging his actions, indication of one state of mind. In the same paragraph, my lords, there is a line which begins with in the middle of the paragraph, which says, even if, Lordships perhaps able to find that line.
Yes, found it.
Even if there is a disobedience of an order, such disobedience is the result of some compelling circumstances under which it was not possible for the contemner to comply with the order. Contemner cannot be punished. And the last paragraph I wanted to show was paragraph number 15 at page number 10. Well-settled principle of law, two interpretations are possible, and if the action is not contumacious, contempt proceedings would not be maintainable. effect and purport of the order is to be taken into consideration, same must be read in its entirety. Now, this, because I'm repeating myself, but the short point I wanted to make was this. Your lordships was of the view in the main judgment of 2nd of February 2024, which was then reiterated in the order of 9th of August in the shape and form of a consent order, that they must have an effective opportunity to rebut the allegations. But it is quite something else to say that in the garb of that, you can ask for whatever that you want, you think it is relevant. Bank has taken a view, they have taken a view, we have declared them as fraud, the matter is sub judice in another proceeding, and that court can then consider looking at both their side and my side as to whether the request was reasonable or not.
Mr. Dewan,
cannot be a matter of contempt.
that other proceeding you referred to, that is against they have been finally declared to be as fraud.
Yes,
Fraud.
so that, my lords, is CAN 1 of 2025 in WPA number 157471 of 2024. It is coming up on Monday.
No, this gentleman is a party, the present petitioner.
Yes, he has challenged it. He has challenged the.
It's his application.
Yes, it is his application.
All right.
Aggrieved by the declaration of him, which is Mr. Hemant Kanoria, as fraud, and his case there in those proceedings is that the necessary documents were not supplied to him.
Understood.
Our defense there is that what you are claiming to be necessary, relevant documents.
Whatever your defense here is the same defense. I mean, obviously.
But according to me, I'm saying there is no contempt case made out. That's my
Let us hear Mr. Chaudhary on this.
Yes, of course. I'm so grateful.
Yes, Mr. Chaudhary. He has a point actually.
He does.
Because if there is a doubt or interpretation involved, here the Supreme Court says if there is some doubt and reasonable, and even if there is some ambiguity in the sense or interpretation is required, they cannot be said to be a willful contempt. They have a defense. So how do you deal with that?
My lord, part of it, my lord, he definitely, my lord, if there is a doubt, part of it is, my lord, definitely he does have a point. But there are two issues which, my lord, arise. Number one, my lord, is today the situation is 12 or 13 of these nationalized banks, my lord, have formed NARCL. NARCL has bought 100% shares of Shrey entities in NCLT, which is why, my lord, they have access to all of Shrey's, my lord, records. And which is why the auditors, my lord, have access to everything. Now, the situation is quite peculiar. Situation is that you, the bank, will have access to all of Shrey's records. You will pick and choose, create a forensic report in FAR, and then on that basis, you will allege that I am a willful default. I am a fraud. But I, on the other hand, will not be in a position to defend myself. Because you'll say, I'm the bank, I don't have Shrey's documents. No, this cannot be the situation.
Not having documents is one aspect of the matter, Mr. Chaudhary, which is a minor aspect in that sense. But their officials were involved in the minutes and all. These are absolutely irrelevant.
One or two are irrelevant, but some are not. My lord, if your lordship looks at, first let me show your lordship what is my reply. So please take the first, my lord, volume 3.
Page 749 and start.
749, yes.
749.
Yes.
So issue 1, my lord, please take. We'll take one issue, my lord. My lord, issue is instances of issues relating to credit exposure to customers classified as high risk. So the allegation is, why did you lend money? Why did Shrey, who was then under your control, lend money to high risk customers? This is, my lord, the sum and substance of the allegation.
But you require the names and details of the officials of the bank. Is it a personal vendetta sort of thing, or you are trying to?
I don't.
You are asking for a roving inquiry, Mr.
No, I don't.
This is fishing out, not even evidence, fishing out the names of the officials personally.
No,
Why do you?
I don't need 1, 2, and 3.
In fact, I am
don't
not
need
adjudicating.
names.
I'm not in a position to adjudicate whether these are relevant.
No. I don't. I'm saying, no, conceding I don't.
It's fishing.
No, but not all. Maybe first one or two.
Your content allegation of contempt is that you sought for a set of documents. They have not given the entire documents.
Correct.
Now there is a qualitative adjudication required on this, whether those are relevant.
Are you even giving me one document? What is your response? So this is like not giving a single document and coming to court and saying that I'm complying with your order. May I just show? Just on one, as a test case, let me show your lordship, what
Yes, 770 are the documents you have sought for
Yes,
one.
but before that, just to show the background. So the allegation is that I have given money to high-risk customers. Now, please come down to page 762. My response starts. Paragraph 51. I would like to state as under.
Yes.
I was the chairman, etc., etc. All that is good. But then your lordship comes to my lord, paragraph 52. With regard to instances mentioned in KPMG report related to credit exposure to high-risk customers, I say that all these loans were sanctioned and disbursed to entities undergoing infra projects, etc., etc. Exposure was secured by charge over future. Then, my lord, please see paragraph 53. Board of both companies comprised of directors, and these were A to F were the committees, A to K, my lord, were the committees of Shrey which actually looked at everything. Then, please see paragraph 54. Credit governance process of Shrey entities was robust, thorough, and institutionalized. Loan proposals were backed by detailed appraisal report or credit assessment memo. There is a well-documented delegation of authority. Now, pre-sanction. So this is what Shrey used to do. A DAR is prepared by the relationship managers at the branches, etc., etc., and the full procedure. Then, post-sanction, pre-disbursement, what happens? So after obtaining sanction, paragraph 56, relationship managers prepare a sanction letter. Sanction letter is signed by this person. Then 58, before carrying out the above checks, the credit administration would ensure compliance with KYC, anti-money laundering. Then pre-audit. Please see pre-audit, paragraph 59. Credit appraisal would be subjected to pre-audit by an independent team, verification of adherence to credit committee minutes.
Sir, surely the moment you have to go into the merits of your objection and whether the documents are relevant or not.
I don't have to, my lord.
Contempt does not occur. I can give you liberty to take a similar challenge that these were the relevant documents were not furnished to you. Upon satisfying the court that those were relevant for this purpose, before the court where a challenge is already pending. I'll give you that liberty.
That is ultimately what is going to happen.
That is in any event going to happen. You will, in any event, without any leave, you will take that.
Yes.
But these points, I'll not close those arguments of
No,
yours.
just two more minutes. I totally agree.
Just a tantamount to contempt.
I totally agree with what your lordship says.
As a pressure tactic, yes, you have succeeded.
No, not
to some
pressure
extent.
tactic.
You extracted some money by having them appoint Mr. Dewan and all. But apart from that,
no, my lord. But it's actually, if one takes a very strict view, what is not being done is, so these are documents. I've just shown this, nothing else. So
adjudication will be required in a contempt.
correct. No, so these are documents I need to answer. So please look at what is happening today. You are saying,
taking advantage of the order, Mr. Chaudhary, you have sought for the details of the officials and all who are involved in the subject loans, and now you are apparently as if you are a whistleblower and you are asking for a scam.
No, my lord.
Whereas the whistle has been blown on you in this case.
No,
you have allegations of fraud against you. So you cannot do this, taking advantage of my order and asking for the names of all officials who are involved. The first three are names of officials.
First three are, they got carried away. But
carried away,
but then they are totally relevant. Now, just let's
appraisal reports and minutes of meetings.
Yes, appraisal reports are relevant.
Merits of
no, appraisal report is relevant. So when I had given these alleged high
I will be
risk,
cautious in future while passing the orders. This is a lesson for the court actually. Don't use such vague terms as relevant documents and leave it to the perception of the parties. We'll be cautious on that and
no.
specifically extract from you what exact documents you are wanting and ask there.
No, but Pilot, please see para 83 once. Names and details of.
Sir Chaudhary, the moment we have to adjudicate on this, or we have to advert.
I agree with that.
And understand whether these are relevant. Contempt does not lie. That is what we are saying. It is not a willful and deliberate violation of an order of the court. Because it's doubtful then. If
Yes.
it's doubtful, there's an
Totally
iota
agree.
of doubt. Yes, be not.
Totally agree. I can't say otherwise.
Then go on to some other matter. I'll pass my order.
Very well. But Milord, what the reason I was trying to, Milord, interrupt and try to say something further is
Yes.
each thing over here is actually relevant.
No, relevance I'll not close here. I cannot.
It is, but I don't
The moment
want
I say that I cannot, it requires an adjudication.
Yes.
Simultaneously, it goes with it that I cannot adjudicate that sitting in contempt. And I'll leave that open for both of you to canvass out before the court, where as Mr. was.
Make the same challenge in an appropriate procedure.
Your GA is pending there. GA or can, what, this is what, GA.
Oh, that's can. No, that's C,
Oh, this
can.
is- can. Yes.
Can.
Milord, may I say this? Let me, Milord, withdraw this with, Milord, the
Liberty.
leave to apply in appropriate proceedings.
Yes, Mr. Dewan, any cost you want?
No, we have already suffered a lot, but no costs are required.
Very. Then I have to record everything, the submissions.
Maybe not required, Milord.
Manoj, I would only request this. There is, of course, Mr. Chaudhary is entitled to have a say, but what fell from your lordships is relevant. Because what has happened is that every single bank is now facing a problem that we are inundated with requests for documents which we believe are not relevant, and our orders of fraud are being challenged on that ground. So
But
at
we
some-
believe they are relevant.
Correct. So that adjudication
your
has to
belief
happen.
versus my belief must be adjudicated.
Correct. So at
this is
least
what we'll go and do that.
So at least we are ad item that the issue is that there is no content made out because there is a contest between what is relevant or not. He is entitled to show they are relevant. I am entitled to show the request is not relevant.
No,
That's all.
would you like to withdraw unconditionally, or you require that observation that relevance will be open? If you don't want that observation, then I'll say that during arguments you sought to
No,
withdraw.
actually, I don't think it's contempt. But I have a good case I want to argue it.
If you want one line of observation, then I'll have to advert to his arguments at least. I mean, he has made his arguments. After that, you're making your prayer. So it will be unfair if I.
No, why should I
The
be
context is not reflected.
Why should I be unfair?
I'll definitely not adjudicate, and I'll give you that leave also. Either way.
Milord, may I take instructions? Milord, there are plenty of people there. Milord, I'll just take instructions, and next Friday we'll come and indicate. We won't try and persuade your lordship further.
Now I'll forget this. I'll record the submissions then. Otherwise, it will be unfair. Mr. Chaudhary. Don't withdraw. Don't withdraw. Don't withdraw.
Very well.
Sorry.
No.
You come back with instruction.
agree, Milord.
The best thing, Mr. Chaudhary,
Is that your lordship, Milord?
let us be very transparent on this. I'll record the submissions.
Yes.
In a nutshell, at least I'll record his submissions, because otherwise it will be unfair
I'll tell your lordship.
for the for
maybe,
them.
maybe not contempt, but I definitely have a right to agitate this.
That is what I'll observe, because that is the reason why I am dismissing the contempt, even if I dismiss.
Yes.
Even if I dismiss, that will be the reason, because this does not amount to contempt since there's a doubt and adjudicatory component in it.
Correct.
That is what I'll have to hold.
Absolutely, Milord.
And I'll give you liberty to both sides.
Yes.
You liberty to raise that and them to rebut before the court where it is pending. I'll do that. Don't require an instruction for a rejection.
No, I don't. I'm grateful.
Then
may I have
yes. So you are actually going to do that? Go to another court and please, you're welcome. Mr. Diwan, you can also leave so that I can pass my orders in peace.
Very well, Manoj. But
No, please don't.
No, I'm here now. I'll put myself on mute.
I talk too much, so it's a talkative judge case. The present application has been filed alleging contempt on the part of the alleged contemner of the order dated October 9, 2024, passed in WPA 1223 of 2024, which was disposed of along with two other petitions by the self-same order. Full stop. Next para. Learned senior counsel appearing for the petitioner contends that in paragraph numbers 8 and 9 of the parent order, the petitioner was given, petitioner was permitted to furnish his reply to the show cause notices issued by the respondent bank within 21 days from that day, indicating the documents which are required to be inspected by / furnished to the petitioner to effectively rebut the allegations made therein. এরপরে ব্র্যাকেটে emphasis supplied, bracket closed. Full stop. Next para. In paragraph number 9 of the said order, comma, upon such reply being given, comma, the respondent bank was directed to fix a date for giving inspection of the documents, comma, if extremely voluminous, semicolon. Alternatively, comma, the bank was directed to furnish copies of the our italics say relevant documents, bracket emphasis supplied, to the petitioner within a fortnight thereafter. Full stop. Next para. It is contended that the alleged contemner has not furnished any relevant documents sought by the petitioner in terms of the said order of this court, comma, giving rise to the present contempt application. Full stop. Next para. Learned counsel appearing for the alleged contemner takes a preliminary objection as to the maintainability of the contempt application, comma, to the effect that, comma, in the garb of complying with the parent order, comma, the petitioner has undertaken a roving inquiry, comma, by seeking particulars and details of entirely irrelevant documents, irrelevant documents and information, comma, which have no no nexus whatsoever to the rebuttal to the show cause notice issued by the bank. Full stop. By way of example, comma, learned counsel for the alleged contemner takes this court through the reply given by the petitioner, comma, which inter alia seek names and details of all officials of the bank who are involved in granting the subject loans, comma, who are monitoring the manner in which the loans were being utilized, and who are scrutinizing the loan accounts, comma, etc. Full stop. Next para. Thus, comma, it is contended that the alleged contemner, comma, on valid grounds, comma, refused to give all such documents to the petitioner, comma, particularly since those were not at all relevant to effectively rebut the allegations made in the show cause notice, comma, as envisaged in the parent order of this court dated August 9, 2024. Full stop. Next para. Learned counsel also places reliance on the show cause notice, which was the genesis of the said reply of the petitioner, comma, a copy of which copy is kept on record. Full stop. Next para. Learned counsel for the alleged contemner places reliance on Ram Kishan versus Tarun Bajaj and others, reported at 2014-16 SCC 204, comma, in support of the proposition that unless there is disobedience of such a nature, comma, which is established beyond reasonable doubts, comma, no penal action can be taken in contempt. Full stop. The Honorable Supreme Court observed, comma, inter alia, comma, that undoubtedly, comma, the contempt jurisdiction is a powerful weapon in the hands of the courts of law, but that by itself operates as a string of caution, and unless, comma, thus, comma, otherwise satisfied beyond reasonable doubt, comma, it would neither be fair nor reasonable for the law courts to exercise jurisdiction under the act. Full stop. The proceedings, comma, it was held, comma, are quasi-criminal in nature, comma, and therefore, comma, standard of proof required in these proceedings is beyond all reasonable doubt. Full stop. It would rather be hazardous to impose sentence for contempt on the authorities in exercise of the contempt jurisdiction on mere probabilities. Full stop. Next para. The Honorable Supreme Court, comma, in the said report, comma, went on to observe that even if there is a disobedience of an order, comma, but such disobedience is the result of some compelling circumstances under which it was not possible for the contemner to comply with the order, comma, the contemner cannot be punished. Full stop. Next para. Furthermore, comma, it was held that the well-settled principle of law that if two interpretations are possible, comma, and if the action is not contumacious, comma, a contempt proceeding would not be maintainable, comma, was reiterated. Full stop, next para, learned senior counsel appearing for the petitioner, in reply, submits that it will be evident from the nature of the show cause notice as well as the purport of the reply thereto that the documents sought by the petitioner were relevant. Full stop, next para, in deciding the threshold issue of maintainability, it is required to look into the purport of the parent order dated August 9, 2024. Full stop, next para, the said order, virtually passed on consent, took into consideration the principles of fair play and transparency and sought to ensure, as evident from the order itself, that adequate opportunity to rebut the allegations made against the petitioner was given to the petitioner. Full stop, next para. In such context, it was observed that the documents which are required to be inspected double inverted মধ্যে to effectively rebut the allegations made double inverted clause in the show cause notice would be furnished by the alleged contemner. Full stop, next para, moreover, the alleged contemner was directed to furnish copies of only the relevant documents to the petitioner. Full stop, next para, the use of the word within double inverted effectively rebut double inverted clause and relevant double inverted clause clearly leave it leave a scope of interpretation, in tune with the respective perception of the parties as to what would be relevant for effective rebuttal of the allegations made in the show cause notice. Full stop, next para, going by the principle laid down by the Honorable Supreme Court in Ramkishan, if there is a scope of interpretation or any ambiguity, there cannot be any penal action on the premise that there was willful and deliberate violation of an order of the court. Full stop, next para, since the alleged contemner had a defense to not furnishing all documents sought by the petitioner, which is required to be interpreted in law, an adjudicatory process is required to precede the decision as to whether those documents were at all relevant for the purpose of rebutting the allegations made in the show cause notice against the petitioner. Full stop, next para, it is beyond the scope of the court, sitting in contempt jurisdiction, to adjudicate, to enter into such adjudicatory process. Full stop, next para, for in an action of contempt, the court is only to see whether there was a clear, willful and deliberate violation or contravention of the order of this court. Full stop, next para, in the context above, this court is of the opinion that the alleged contemner cannot be labeled as a person who willfully defaulted any order of the court. Full stop, thus, no contempt lies. Full stop, next para, however, it is made abundantly clear that this court has not entered into the merits of the respective contentions of the parties as to what would be the documents relevant or required by the petitioner to effectively rebut the allegations made against the petitioner by the respondent bank in the concerned writ petition. Full stop, next para, it is kept open for the parties to argue such issue before the writ court where, we are informed, a challenge by way of a writ petition is pending against the final declaration of the petitioner as fraud. Full stop, next para, in the light of the above observations, CPAN 1989 of 2024 is dismissed as not maintainable without any orders to cost.
Great.
Thank you.
I'm deeply obliged.
Thank you so
It was
much.
grateful. I'm so deeply obliged.
Thank you. Thank you. None appears for the parties at the time of call, full stop, as a last chance to the petitioner to move the contempt application. The same is adjourned till February 20, 2026.
Lordship, I am appearing for the petition.
Yes, what is the matter?
Your Lordship's order dated 7th May 2024.
Right.
But,
What was the direction, Mr. Shashwan?
the direction was, my lord, paragraph 8 and 9, page number 18. Direction upon the SDO to
Unlawful
initiate
encroachment.
proceedings, unlawful
What
encroachment.
have they done?
Lordship, after receiving my contempt notice,
Yes.
the SDO has started a proceedings. Kindly, Lordship, have a look to page number 40. I have annexed it. It seems like the proceedings has been started backdated after receiving my notice. Here at the top right, order sheet dated 7/8/2025, and the left bottom, well, order number 197/2025.
That is the magic of contempt.
Lordship, the SDO is still continuing the proceedings, till not concluded.
Let me check up just. The petitioners allege that, in violation of an order dated May 7, 2024, passed in WPA 12278 of 2024, the alleged contemner initially did not even start any inquiry or proceeding with regard to unlawful encroachment by the private respondent in the writ petition on PWD land, in terms of the representation of the petitioners. Full stop, next para. However, upon getting a notice of contempt, apparently an order sheet was prepared on August 7, 2025, antedating, ANTE, antedating the same, which will be evident from the fact that the first order passed therein is dated July 9, 2025, whereas the order sheet itself is stated to be dated August 7, 2025. Full stop, next para. That apart, despite having purportedly started such proceeding, the same is not being taken to its logical culmination. Full stop. In paragraphs 8, in paragraph number 9 of the parent order dated May 7, 2024, it is seen that in the event it is found prima facie that there is an encroachment, due proceeding was required to be taken out by the alleged contemner under the governing statute. Full stop, next para. Accordingly, it is doubtful whether there has been due compliance of the order dated May 7, 2024. Full stop. Thus, since a prima facie case of contempt has been made out, the petitioners shall serve how many contemners? One.
No, my lord. 4.
যেখানে alleged contemner বলছি, alleged contemners হয়ে যাবে সবকটা। Shall be served on the alleged contemners.
Or 5.
Yes, alleged contemners, indicating that the application shall next be listed for hearing on. How soon can you serve? Should you keep it on March 6th of March?
6.
2 weeks, 3 weeks.
My lord, 3 weeks.
Very well. Listed on March 6, 2026. Full stop, the petitioners shall file an affidavit of service to that effect on the returnable date. 6 March is 3 weeks approximately.
Great.
But serve immediately so that they know of they have some time to prepare.
Item number 16.
Yes. Yes.
My lord, may I please, your lordship?
Please.
My lord, I have just gone through my lord's record of my review application. It has been marked as defective on the point of that wakalatnama has not been filed by me. My lord, if my lord takes the original CO application, the file of the original CO application, the Wakalatnama was filed with the CO, with the CAN application. I filed a recalling application previously, which I withdrew, and thereafter I preferred this review application. My Wakalatnama was filed with the recalling application. I believe perhaps it would lie in my lord's court record. Otherwise, I have to.
No, obtain another, because review is a different proceeding. You took liberty.
My lord.
But if that was converted, that would be automatically treated to be a.
My lord,
you are
my
right.
lord, my lord.
It's a technical objection, but technical objection sometime, because otherwise, if subsequently his challenges comes and challenges you, suppose you lose the application.
My lord, I understand.
Challenges your power. You will be in jeopardy, and a fraud will be alleged against the court.
That is, my lord, the point which I was also intending to learn from my lord, because if there is a requirement.
No, if you are absolutely right. If the recall application was converted to a review, then the same proceeding continues.
My lord.
But since that was dismissed or withdrawn or whatever,
withdrawn with liberty to file a
this is a new proceeding
that extinguishes and new proceeding come up.
Yes.
My
There's
lord,
a bona fide doubt of will record. Will give you some time. I will give you a 4
my
minutes
lord,
time.
my lord, my lord.
Where does he stay or she stay?
Uh,
Neelachal, eat.
My lord, this is an.
Your appearance won't do that. This is not meant. You are not important at all. Till now, you're not opposing. I'm not opening my. So Neelachal has to be. Cosba, obtain it. Come back next week.
My lord,
File it in the department. In the meantime, give us the H number.
The only difficulty is the applicant, third applicant, Kaushiki Maholan Bish. She is very much ill. She is actually hospitalized. But
no, there's only one. Neelachal is the only.
No, my lord. I am.
Oh, you are the other side.
My lord. I am representing the respondent number 7, 12, and 19 in the main CO, who are the review applicants.
When should you keep it?
My lord, kindly gives me 2 weeks time, because I need to check whether Miss Mohalanbish is ready to sign it.
You are not enjoying an interim order in this. We have not admitted.
I am not enjoying. They are enjoying, and I am against that only.
So then we can grant time to you, because you would not gain any advantage by asking for.
My lord. Kindly, my lord, fixes after 10 days. That will be okay.
Then we'll keep it on. Today we are on 13th. We are keeping it 2 weeks after 27. 27th. I take it up on Fridays only.
27th will be okay, my lord.
Both sides are represented by counsel. However, it transpires that no Wakalatnama was filed on behalf of the review applicants along with the review petition, along with the memorandum of review. Next para. It transpires upon hearing learned counsel purporting to appear for the review applicants that there was sufficient bona fide reason for a doubt in that regard. Since learned counsel was apparently under the impression that as previously an application for recall of the parent order was made, with which Wakalatnama was filed, which was subsequently withdrawn. No, the same was subsequently withdrawn, and the present review application was filed, there would be no necessity of a further Wakalatnama. Next para. However, since the recall application was not converted to a review application, but was disposed of with liberty to the petitioners to file a fresh review application, the present review application, for all practical purposes, is an independent and new proceeding, and as such, it is required that a separate Wakalatnama be filed on behalf of the review applicants. Accordingly, on the prayer of learned counsel, having instruction to appear for the respondent review applicants, the matter is adjourned till February 27, 2026, when it will be next listed for hearing. In the meantime, the learned advocate having instruction to appear for the review applicants shall file an appropriate Wakalatnama in the department and furnish the necessary details for it to be tagged with the main file when the matter is next taken up for hearing.
And one more point, my lord, let the matter retain its position in the list, my lord.
Probably next week there will be only 1 or 2 applications. We don't know.
My lord, my lord.
Upon curing of the defect, a copy of the review application may be given to us.
No.
It is already served.
Has not been given. No copy has been given.
No, it was already served. I am having an affidavit of service. My lord, kindly seize, my lord. Original affidavit of service.
Give another copy.
Review application along with
He'll
CAN
bear the
110.
expenses for the photocopy. Bring another copy. Since he does not have a copy, his client has swallowed it. You just give it to
In the
him.
meantime, my client.
I'll not put it in my order because
Nilachal
they
is
have already
actually
served.
swallowing almost everything, not only a copy, my lord.
That is very deep. That is very deep. We'll decide on the next one.
All the rights of the members too,
You are the members.
my lord.
And who is he? I mean,
Nilachal.
The society.
the society. Usual villain.
My lord knows it more than me.
Not in all matters. We don't have a fixed notion. This is just a comment. Some matters.
My lord, I will
We are
be
sitting
there.
for these matters only now.
My lord, I understand.
Thank you.